you or whether you can answer this query. I would like to know from you whether you can get a mortgage released in the same manner as a secured interest or a security.
No, Your Lordship.
Under surface C, you can always get a secured property released.
Yes, sir.
But a mortgage property can be released in the same manner is still a question which needs to be examined, or whether it might have been examined somewhere.
Yes.
You will have to assist me on that.
I will assist, Your Lordship. I will assist.
Because the properties are different. Nature is different.
Yes, sir. But here, Lordship, the case is different, Your Lordship.
You have said that it is mortgaged.
It is mortgage, Your Lordship.
So it is not different.
It had.
And you are asking for using section 14. In another case, you had made a mention, remember, day before, 2-3 days back.
Yes, sir.
You argued one other case with regard to.
Yes.
Thereafter, I was examining this provision, and therefore I want to know from you.
Your Lordship, district in that case.
Please assist on this.
Yes, sir.
Find out and come again next
Your Lordship.
next week or next to next week.
Yes.
All right.
Your Lordship, the direction may be given to your at least counter.
You can't be allowing your petition like this. Unless you don't want to answer the queries of the court.
No, Your Lord, I am ready to assist the court, Your Lord.
Then,
Ready.
of course, you do it.
Yes.
List after 2 weeks.
2 weeks.
4th, 5th, what date? Take a date. Give us on what date you will be prepared with it. 4th, 11th,
Yes, Lord.
11th.
On 11th.
11th.
Item 27, Mr. Rajesh Prasad Chaudhary.
Well, this is against the award of Liverpool under Industrial Disputes Act. By the order number 7, dated 24th of August 2015, the operation of the order under award under challenge has been stayed. And perhaps, my lord, an application has been filed on behalf of the workman respondent.
Under 17B.
That we have paid. Now they have paid, they are saying that even after attaining the age of superannuation, he ought to have been allowed the same benefit for that purpose.
For 17B to continue.
Yes.
So after he attained superannuation, you have stopped 17B.
Stop, yes. This is, and I have challenged the award on various grounds. On the ground of territorial jurisdiction, on the ground that on earlier 2 occasions, no.
I am appearing on behalf of the respondent number 3.
Workman.
Respondent number 3.
That is workman, yes.
So this application is yours.
Lord, 2 weeks time.
What do you have to say with regard to this application? IA. Yes.
He is seeking time.
प्रमोद वंश यूरोपियर हैं, आप नहीं हैं, अभी तबीयत खराब है।
अच्छा, you are appearing on behalf of some other council?
Yes. He is asking for time.
Council for the respondent number 3, stated to be unwell, list after 4 weeks.
Item 28, Mr. Ved Prakash Vastav.
That we could not locate the petitioner. In the last occasion, we were directed to high substitution of teachers.
Substitution petition has not been filed as yet. You want time?
That it may be dismissed for non-compliance of order. We are not very
Counsel for the petitioner
non-compliance में कर दिया. Perhaps he has left the India. That is the problem.
But the retail outlet has been commissioned in way back.
Respondent number 7 has expired. During the pendency of this writ petition, his LRs have not been brought on record. Writ petition stands abated.
Item 29, Mr. Bernard Thakur.
Can only 2 weeks time be granted? The counsel for the petitioner has some knee problem, arthritis problem.
भाई ये तो 2013 के केसेस हैं. वी आर नॉट एक हमने पहले दे दिया. ये तो सभी
उनको घुटना
आई एम अमेज्ड द वे एडजस्टमेंट्स आर सॉर्ट हियर. ये बीमार है, इनकी जुकाम खांसी हो गई, ये हो गया.
नी में आर्थराइटिस का प्रॉब्लम है.
तो होता है, कहीं को होता है. ये तो
मूवमेंट करने में उनको दिक्कत हो रही है.
सबको ही होती है.
2 weeks time my lord may be granted to.
वकील साहब उसकी वजह से रुकेंगे नहीं. That we know. How much practice does he have? हाँ जी पिटिशनर है.
27.
फिर 27 साल पुरानी वकालत करने वाला वकील इन सब छोटी मोटी वजह से नहीं रुकता. उसको अगर केस आगे करना है ना,
मूवमेंट में दिक्कत होती है, इसीलिए वो कोर्ट 3-4 रोज से कोर्ट नहीं आ रहे हैं. That's why I have mentioned, my lord.
और आपके यहाँ तो एक प्रेसिडेंट है जो काफी बड़े बुजुर्ग हैं, फिर भी है ना वो करते हैं.
आज भर के बुजुर्ग पास वर्क करते हैं.
आप बहस करिए, वो आपके ऊपर छोड़े हैं.
प्रोवाइड कर दिया जाए. हम
क्या प्रोवाइड कर दिया जाए?
लीव को प्रोवाइड कर दिया जाए, हम तैयार हो जाते हैं.
हम क्यों प्रोवाइड करेंगे? Why are you asking the court to give you a brief?
My lord, actually, the brief, the learned advocate has carrying this brief. Right now I have no brief. That's why I am mentioning that lordship is providing me the brief. I will argue before this lordship.
पास ओवर करके बुलाई. आफ्टर 2 जुलाई.
आज भर के लोग मूवमेंट में कल आ जाएंगे, जो हम कर देते हैं.
Not here.
No, he is not here.
Also for the petitioner is not available. List after.
Well,
Item 30, Mr. Suraj Prasad.
My lord, I pray for a very short adjournment, 2 or 3 days. My lord, I may be given to file counter
The
affidavit.
2013 matters, Mr.
Yes, my lord.
Counsel.
My counter affidavit is ready. The person who has to sworn the affidavit, he is outside
We
Patna.
have
my
not
lord.
filed counter affidavit for so much time. We can't be
My lord,
giving you after 10 years time to file counter.
I'm very sorry, my
What is
lord.
the case?
Lord, this case is for the payment of the money
Payment
against
of
the
money?
work done in the year 2011 itself.
Or?
One thing I may
For
submit, my
execution of
lord,
the
he has
public
not
works,
annexed
my
the.
Wait, please.
We have executed the work in the room. We have completed the work in the year 2011
For
itself.
contractual work which
Yes.
you have completed.
Yes.
Then why didn't you go to the court, civil court,
Lord,
for claiming your dues?
my Lord, we are pressing
Why
our
are you
claim
here?
on the basis that the statutory duties had not been performed. As per agreement, we have performed and they have paid.
It is
The
not a
balance
statutory
amount is-
contract.
My Lord,
It is not a statutory contract.
statutory contract, yeah.
How it is? Because the state is involved. Then it becomes a
No, 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 no.
statutory.
This is the work done under the RCD, my Lord, Road Construction Department.
Yes.
Earlier, the agreement was executed.
So
Yeah.
it was an open tender issue.
Yes.
So everyone has participated. It is not a statutory contract.
We
Awarded to you.
have participated, the contract is awarded, we have executed the work, payment has been made. And rest,
Yes,
some
we-
balance payment are concerned.
So if balance payments are concerned, Mr. Counsel, this is not the writ jurisdiction to decide what balance is allowed to be paid, what is not to be allowed.
The bill has already been last bill, final bill has been passed.
Who is
And
going to approve it?
the bill has been already approved, my lord.
Who is going to prove this? Who is going to prove?
I have annexed the copy of the bill, approved bill.
Is it a forum in writ jurisdiction that we can hear and decide whether you have completed the contract or not?
No,
You will have to prove it in a competent court.
it is not under dispute that the work is not completed. Work is completed. Payment has been made.
The
Only a
official judge
few
cannot
amount,
dispute, say or
only a few amount of balance payment is rest upon them of the enhanced rate which they have approved. Must be for me.
please satisfy that the writ petition would lie. Justice Shah का judgment निकालिए बस Supreme Court का.
My lord, kindly have a look over my supplementary affidavit, page 24. This is the 14th and final bill passed by the authorities. From page 24,
Where is the completion certificate?
because it has not been brought on record. For that last occasion, my lord, the Honorable Court has directed.
2013 case is pending. You are keeping it pending. You have not brought a completion certificate. Where can be said that no, you have completed your
It
contract
was
on
never,
your part.
it was
You
never
might
denied,
be,
my lord.
it might be that you have not completed the work,
Kindly have a look over the order dated
or there might be a 1 year.
20th of March, my lord, kindly last order.
Sir, counsel, why I am asking you all
Lord.
these questions is only for simple reason that these are not the questions which we can examine in writ jurisdiction.
I'm sorry, I am intervening, my lord. I am intervening, my lord. I have just received, my lord, the instruction. My lord, there is a clause
Mr. Counsel,
20.
please sit down.
My lord, just clause
I
25.
don't
Lord.
like these kind
Lord.
of chorus arguments.
My lord, 1 week time will be granted. I will bring out the record the
You
completion certificate.
satisfy that writ petition
Yes.
would lie. You satisfy that writ petition would lie before this court
My lord, once a
for payment of contractual amounts.
keep it after 1 week, my lord, I will fully satisfied, my lords.
Supreme Court has already laid down
My lord, I will try to satisfy my lords.
with the latest judgment of the Supreme Court which says
I will also examine that, my lord. I will also examine it.
My lord,
courts ko rakhiye.
my lord, agreement
Counts
provide
for the petitioner to
Right.
satisfy the
My lord.
maintainability of a writ petition
clause 25 of
with regard
the,
to claim of.
my lord, clause 25 of the agreement
We
provide.
have closed we have not allowing you to file a reply. You have not done it for last 10 years.
Lord, there is arbitration clause, my lord, there is arbitration tribunal.
that we will see.
Agreement provide, my lord, that any dispute will go to the arbitration tribunal. It is very much written here, my
Is it
lord.
there?
Repeated,
Yes, my lord, he has not annexed-
notes are there, even
he has
the
not
admitted
annexed-
even,
he has not
admitted
annexed
is
the copy.
directed to be paid.
He has not annexed that. This is a fact. Just now I have received this, my lord.
तो पेश करिए ना उसको
हम टेस्ट कर देते हैं
4 तारीख को रखिए.
oblige my
Item 31, Mr. Dharmesh Kumar.
May it please, sir. Lord, the issues involved in this case, there is so many, but on the last occasion, the respondent has made an offer that I am ready to settle the dues at rupees 4 lakhs, and then the order was passed on the last occasion. And I have made an offer that yes, I am ready to accept your offer, but they say now that I have to get approval.
I have to get.
Approval again. Once he has made an offer in the counter affidavit itself by filing an IA, that I mean, be that as it may, without reverting to the issues involved, they said that if you pay 4 lakhs, we'll close the account. I have accepted before this honorable court, and that is that.
Have you deposited that 4 lakhs?
No, my lord, I have not deposited, but if he's.
You should come with that draft as per their IA. To file your reply with the draft.
Lord,
Within 2 weeks, my lord, I'll come with the drafts, my lord.
Lord, the offer of 4 lakh was given in the year 2021. 2 years have lapsed. We have to take fresh approval from RBI. That is what we have communicated. We are agreeable to the offer.
For the petitioner, respondent states that the offer was made for a total sum of rupees 4 lakhs.
Yes, in 2021.
For closing the account, closing the loan account of the petitioner. The said offer was made in 2021. The learned counsel submits that fresh approval is required From their head office?
RBI, my lord.
From,
RBI.
From RBI for what?
For the closure of this account, my lord. The problem is that this.
Is there a procedure to get approval from RBI?
My lord, the company is RCEL, so they have been assigned debt from the bank. So for closure of this account, they need to have an internal approval as well as from the RBI, because
from the RBI, he may take the said approval within 15 days. In the meanwhile, the petitioner shall keep ready a check of a draft of ₹4 lakhs.
Yes. In the name of he may indicate what is in the name, in whose favor, because earlier it was
RCEL.
Yes, RCEL. Because the earlier
on the next date to show his bona fide.
The lender was ICICI Bank. It was taken over by the RCEL.
List again on after 15 days की date लीजिए.
But 3 weeks may be given because 15 days.
After 15 days का मतलब date 3 weeks क्या? 11th है. Most of 11th day.
11th. Item 32 available in file.
File is not available. बता दो.
Item 32 का file available नहीं. Item 33, Mr. Vinod Kumar.
First taken away, third one not. First taken away, third one not. 3 cases which are.
33 is किसकी है?
Would my lord be kind enough just take the file of Inavia Food Beverage? My lord, there are a batch of petitions dealing with the same issue. My lord, relating to food processing units, your lordship. My lord would just kind enough to take the file of Inavia Food Processing Unit, your lordship. CWJC number 9026.
33 point which one?
3.2, your lordship.
3.1. 3.2?
Inavia Food Beverage.
33.2 or 33.1?
2, your lordship.
Yes.
Now, my lord, the only issue in these petitions was as with regard to entitlement of petitioners unit under Bihar Industrial Policy 2011. Now, my lord, since the subsidy, the food processing subsidy of 35%, which the petitioners were entitled, my lord, these were.
What is the case? What are you aggrieved of?
Now,
let us know first what is your case.
Yes, your lordship.
Then come on the facts. Who is appearing for the other side? Who is appearing for Industries, Food, Director Industries, Union Bank of India? Anyone appearing for Union Bank of India, State Investment Promotion Board?
Union Bank of India, my lord, I am representing in this case, my lord, and they are.
How are you?
And AG7 is appearing, my lord, in this on behalf of the state.
What is your petition against the state?
Yes, your lordship.
Huh?
Now, my lord,
against the state action?
Yes, your
What
lordship.
is that action?
Now, my lord, petitioner has established a food processing unit.
We are again asking you what is the action which you are aggrieved of?
My lord, we were seeking grant of subsidy in terms of the Industrial Policy 2011, your lordship.
From the state?
Yes, your lordship. We were, my lord.
So who is appearing for the? So Director Industries issues the.
Yes, your lordship.
Subsidy.
Yes, your lordship. My lord, they have granted us, a State Investment Promotion Board has granted us approval. And my lord,
but since nobody is there, I have to first see this. You can't be arguing case without. Who appears for the state?
AG7 in this matter.
Double AG7. Who is double AG7?
Mr. Jogender Prasad Singh.
Mr. Jogendra Prasad Singh.
Sinha.
Sinha. Counsel for the state is not present. Let's this case until on 4th. 11th date. 4th date.
In first I am present for the estate matter. First में हम estate के तरफ से appear कर रहे हैं. 33 first.
मेरा एंजाइटी है.
आर्ग्यू कर लेंगे सारे केसेस एक साथ.
सारे केस का फैक्ट हम हो गया.
इशू आप बहस कर लेंगे जो मेन इशू है.
इसमें मेन इशू
कमेटी आप बाद में कहें नहीं साहब वो करेंगे.
इसमें कमेटी बनाने की बात चल रही है जो अप्रैल में कमेटी बन जाएगी जो इसमें प्रोसेस में है.
हाँ तो आप 11 अप्रैल को बता दीजिएगा.
इसमें ऑलरेडी केसेस हैज बीन डिसाइडेड माय लॉर्ड. उसमें कह दिया गया कि ईच एंड एवरी पिटिशन इंडस्ट्री इस ओन फैक्ट्स में इनको देखना है एंड द डिपार्टमेंट विल लुक ऑन ईच एंड एवरी फैक्ट एंड दे विल टेक फ्रेश डिसीजन. ये बिहार इंडस्ट्री में हो गया है जो रिपोर्ट का. तो ये लगेगा इनका भी सिमिलर ग्रीवांस है वहाँ पे.
आकर बताएगा स्टेट की तरफ से काउंसिल
डेट में हजूर शॉर्ट डेट दे
11 तारीख की दे रहे हैं.
शॉर्ट डेट दे दिया जाए.
4th रख दीजिए.
4th.
चलिए.
Item 34. Please, Your Lordship. Lord, with respect to the first and second relief, Lord, that has become in. With respect to the first and second relief in this petition, Lord, that has become infructuous, Lord. So I will be limiting my argument with respect to the third relief at page number 4, Lord. For a direction to state government.
First prayer is A, B has become infructuous.
Yes, my Lord, I withdraw that. With respect to the last prayer, my Lord, for a direction to the state government to enhance the present rate of commission suitably, double the present rate to enable the existing PDS shop licensee to meet the minimum requirements of their living as guaranteed under Article 21 of the Constitution, Lord. With respect to this, my Lord, I only pray that I may be.
What is the commission which they are providing?
Right now, my Lord, in 1 quintal they are providing, my Lord, 40 rupees, my Lord. So, as per their calculation, my Lord, it comes to around 2,000-3,000 per month, my Lord. They are able to earn 3,764 per month. That is a very 3,764 per month, my Lord. At page number 14, my Lord, para number 14.
On one particular food product.
One particular PDS shop gets that, my Lord, earns that much of amount, my Lord.
For all the material which they are providing? Kerosene?
Food grains, my Lord, they are earning 2,222, my Lord, and in kerosene they are earning 1,542. Totals comes to 3,764, my Lord. It may increase or decrease depending upon the quantity they sell, but this is a tentative amount that they were earning, my Lord. So I am only seeking, my Lord, direction that this rate may be enhanced, my Lord. At least the state government should consider enhancing that rate, because at such a low rate, my Lord, their sustenance and living is at stake, my Lord. So the state is effectively, my Lord, not giving that proper incentive to operate that. And that can also be one of the reasons why they are not operating it properly.
Who appears for the state? You appear? Who you take notice? Appear in this case, file your reply.
Obliged.
Learned counsel for the petitioner does not press prayer number A and B. However, he prays that the commission which is being paid to the PDS shop owners deserves to be enhanced. Counsel who normally आप appear क्या?
नहीं, इसमें कहना है कि हमको अभी पता चला कि इनहांस हो गया है, कमीशन इनहांस हो गया है.
Counsel for the who appears normally for the respondents is directed to accept notice, file his counter.
Right.
3 weeks.
4 weeks कर दिया है, क्योंकि हमको ब्रीफ लेना पड़ेगा.
4 weeks.
Item 35. Rajiv Kumar Lal.
सिमिलर हुजूर कल भी हम प्रेयर किए थे, सिमिलर मैटर जो आज लिस्टेड है 46 पर, which has been probably adjourned for a week, my lord. This may come with the said case, my lord. CWJC number 12694 of 22. In this case, Advocate General has to appear, my lord.
उन्होंने तो 2 हफ्ते का टाइम लिया।
2 हफ्ते का, जो ठीक है, तो उसी के साथ लगा दिया जाए।
6 को ना
हम नहीं थे उस समय।
46 को 2 वीक्स के बाद सुबह किया था ना, उसी डेट दे देना उसमें 46 पे
साथ इसको भी अलॉन्ग विद कर
उसको अलॉन्ग विद 46। In this case, copy be served on the office of the Advocate General, who is appearing in a similar case. कभी आप दीजिए नोटिस।
जी।
Item 36 with analogous case.
Lord, in this batch of cases, my lord, I had taken time, my lord, for filing supplementary counter affidavit, my lord. Today the affidavit is going to be prepared, so I would pray for further 2 weeks time, my lord. Actually, it takes 3 days, my lord. First of all, e-filing is to be done.
On the last occasion,
दीजिए आगे करिए। Counsel for the respondent wants time, 2 weeks time to file counter affidavit as a last opportunity. 2 weeks time is granted. List this case again on 18th of April.
Hello, this case will be
item 38.
Serial number 38 is also same matter along with this batch. This all these batch cases.
जो
जी हाँ
इसमें भी काउंटर एफिडेविट फाइल कर दिया गया
38 सीरियल नंबर में।
बट तो ये है ही नहीं।
My lord, hi. He is also appearing. I myself have petitioner. In batch case also I am at serial number 3.2, 36.2 and 38 serial number.
टैग कर दीजिए 38 को भी उसी के साथ।
जी हाँ।
टैग दिस केस अलोंग विद
लास्ट ओकेजन पर टैग हुआ था, लेकिन पता नहीं किसी सेपरेट।
आइटम नंबर 36 के जो है ना केस
This state has already filed counter affidavit. 38.
18 को रख दो।
EPFL has also filed counter affidavit in this matter.
In this case, my main contesting party is Sugar Corporation and EPF.
Are they appearing?
Yes, my lord.
I am appearing, your lordship.
Sugar Corporation.
Sugar Corporation is the employer and he. My lord.
Item 39.
18.
They can receive the last order, millers, despite notice issued to the corporation millers.
As a matter of last indulgence, my lord, may kindly grant only one last adjournment. We will file counter.
As a last opportunity, 3 weeks time is granted to file counter. List this case thereafter 25th April.
Item 40, Mr. Krishna Kumar Tiwari.
my lord, insurance matter, my lord, and earlier notices issued to Bajaj Allianz LIC Corporation, my lord. But no counter affidavit. Matter
You are challenging order of ombudsman. Ombudsman is their person. You go and file a civil suit for claiming your raising your claims.
In several cases we have appeared and we get the relief, my lord, by this court.
Show any relief given.
On next date, whether, my lord, if any counter has been filed or not, my lord.
We are objecting to the maintainability of the writ petition.
On next date, I will give reply to the suspect member.
कोर्ट में ऐसा नहीं होता ना कि नेक्स्ट डेट पे रिप्लाई दे, आज क्वेरी करे, कल कोर्ट में जवाब दे, परसों फिर रिजॉइंडर दे।
जनरल प्रैक्टिस है कि हम लोग
ये जो जनरल प्रैक्टिस है ना, वो प्रैक्टिस नहीं होती है कानून में।
बैंक
कानून होता है, यू हैव टू फॉलो दैट लॉ। प्रैक्टिस इज नॉट व्हाट इज लॉ। Law has to be strictly followed. Jurisdiction cannot be extended beyond what is there available in law. Let us know what is your right, legal or fundamental right which has been taken away. Writ would lie only for that.
As your lordship think that proper court is civil court to decide the matter.
No, you can go in consumer court also. And now there is another forum which has been created known as Permanent Lok Adalat. I don't know, in every district it must have been now established. If not, it will have to be established. Where you can raise your dispute up to a sum of ₹1 crore, money suits, with regard to electricity, with regard to insurance, with regard to claims of against.
But there is some question. My lord, there is some question deciding the certificate, my lord. In proof of age.
This is what they have said, no?
Yes, ma'am.
They have denied you. You have a right. You say that no, my certificate is valid. My certificate is valid. This is what you are claiming. So if your certificate is valid, that the court will look into, and whether it can be gone into at the time of claim. That is also an issue which the concerned court will examine. Ombudsman has rejected, that's all right. But Ombudsman is an officer of bank.
Then your lordship may send you to Lok Adalat.
Why should we send it? We are neither, we can't be, the court cannot be a party to any litigation, no?
No.
So why should we send it? Suppose if you go to a particular forum, you will have to put it in a proper format, you will have to file it, the procedure which is required in that particular court is required to be followed. You have filed a writ petition with ₹125 or 25 rupees. I think it is 25. यहाँ कितना है कोर्ट फीस? रिट पिटीशन पे कोर्ट फीस कितनी लग रही है आपके यहाँ?
300 करीब 300.
300 तो वो टोटल है. रिट पिटीशन फाइल करने की कोर्ट फीस तो 25 रुपए ही है. Counsel for the petitioner. Likhiye, the writ petition has been filed for claiming the insurance amount. He also challenges the order of the Ombudsman. The Ombudsman is an officer of the bank, of the insurance company, and the claim has to be filed before the appropriate forum. Interest on the said claim can also be granted by the concerned forum available to the petitioner, which are more than one, namely Consumer Court, the Permanent Lok Adalat or the Civil Court. The petitioner has, however, this court is however firm of its view that the writ petition would not lie for claiming insurance amounts, as it involves proving of documents and evidence. The writ petition is accordingly dismissed with a full supplement.
Dispose of with this observation.
When we say it's not maintainable, it has to be dismissed.
Item 42, Mr. Arun Kumar. Item 42, Mr. Arun Kumar.
My lord, in this matter, one-time settlement has taken place. In that context, I am filing a affidavit also today. It may be taken tomorrow.
आपको पता ही नहीं?
No, my lord. Government has given my lord of subsidy. And except very kindly see your lordship.
For the, you are appearing for the bank?
Bank, please.
Bank.
Please, lord.
And
Also
except very
appearing
kindly
for
see
the
your
Allahabad
lordship.
Bank states that a one-time settlement has already been arrived at between the petitioner and the respondent bank. The said one-time settlement is being filed
My lord,
by way of a
notice has been issued. Except for
This counter affidavit
By way of
is
which?
going to be filed, my lord. Today it will be.
shall be filed by way of counter affidavit. Copy of the same may be provided to the counsel for the petitioner. Lest this case
last time
again
my
on
earlier
fourth.
he has also given time, taken time.
Time I am not taking. It may be disposed of. Subsidy has not
क्या
been
करें
given.
My lord.
क्या करें, नहीं दे इनको टाइम? बताइए बताइए क्या करेंगे? Whatever you say. We close his reply.
Bank, my lord, he has taken.
The government is appearing.
Lot of time. Cost? क्या करें? Admit कर ले.
For subsidy petitioner has come before your lord.
Admit कर ले. If he doesn't file reply, फिर से notice issue हो जाएंगे. Next case.
Item 43.
Fourth.
Please.
We listed on 4th. 4th April.
Please, lordship.
Next case.
Item 43 with analogous case. Mr. Dayanand Singh.
Yes.
Please.
There are two writ it was taken up just few days back. There are two writ applications against the same award passed by the tribunal. One by the worker side and one by the State Bank of India. The State Bank of India has challenged the award. The worker is simply seeking enhancement of whatever compensation that has been given by the award. So that is why your lordship said that in that case the bank will have to be heard because we are challenging the award. But this is an industrial dispute matter, your lordship. I think the understanding was that it will be taken up on Friday. Suddenly it's come up today. So I have no issues. I'm ready to argue the matter on behalf of the bank.
Argue? Who's stopping you?
Fine.
My lord, in case.
You are for the workmen?
No, my lord, I am for
My
the
lord, serial number 40. My lord, the limitations will be. Insurance matter, my lord, which is already disposed of. I clearly that lordship may.
Go there. Move an appropriate application for condonation of delay of pendency section 14 limitation act. वो भी लिखाएं क्या?
नहीं.
फोरम बताएं, लिमिटेशन का प्रोविजन बताएं. What are you?
उसको इग्नोर कर देखो.
चलिए.
Lordship, the award which is under challenge is at annexure 1, page 28 of the writ application, that is 10247.
You are ready or not? Tomorrow, after some arguments, you say that no, I am not ready.
I am ready, but only this pass over for few cases. My
What?
file is not with me. Actually, I've called somebody to. It is it. For few cases, my lord. I am
You are
ready.
here, your file is not there.
My file was there. Actually, I have.
Somebody has taken it away.
No, my lord. I was on the legs before some other court. I had to run. That is why. 5 minutes. I mean, only for few cases, and then.
Let him start.
My lord.
If you are you otherwise you are prepared with the file. पर आपकी फाइल मिल जाएगी क्या?
Yes, my lord. 5 minutes max. 5 minutes max. 5 minutes.
आप ले आइए ना जब तक हम बहस करते हैं.
हाँ. और हमें शक है कि फाइल मिल जाएगी. लंच के बाद रख लेते हैं.
रखिए, कोई दिक्कत नहीं.
आफ्टर ब्रेक. Get your file.
At 2:15.
And keep it under your possession.
Yes, ma'am.
Secured possession.
Yes, ma'am. Item 44 is not available. Item 47. Mr. Dhanajan Atiwari.
Lord, I am in 44, Lord.
Yeah?
Serial number 44.
Item 47.
Lord, sir. Serial 44, my lord.
44 is not available.
File available नहीं है. Yeah, your petitioner is a PDS dealer, and his license was inspected on 21/11/2021, lordship, and thereafter, lordship, 7/12/2021, lordship, the FIR was issued against the petitioner, and as per the Section 20, Rule 28 of the Bihar Targeted PDS Control Order 2016, lordship, the license was suspended after the issuance of the FIR, lordship, and subsequently thereafter, lordship, more than the year has been already lapsed, but till date, lordship, the suspension order has not been revoked, lordship, and no final order has been passed, as stated in para 10 of the writ application, lordship.
No reply has come forward.
Lord, it may come after a week, my lord. Chunki reply आ गया as well. Under
the last opportunity granted to the petitioner respondent to file reply. List again after 3 weeks.
Item 48. Mr. Ajay Kumar Singh.
May I please, your lordship? Facts of the case, my lord. In this case, my lord, Electricity Department made a raid in the hotel of the petition, my lord, and he found, my lord, that he was using 14.388 kilowatt, my lord, though he was allotted only 10 kilowatt, my lord, and he fined, my lord, as rupees 5 lakh and 5 lakhs and amounts, my lord. Thereafter, my lord, the petition filed application, my lord, and thereafter the electricity found, my lord, that he was using only 9.102 kilowatt, my lord, and fine was also reduced, my lord. My lord, my humble prayer is, my lord, that the section 126 of the Electricity Act has not complied, my lord. 126, section 126 says, my lord,
Electricity Act, you know. (126)
Section 126, my lord. Investigation and enforcement. Electricity Act, my lord. If on an inspection of any place or premises or after inspection of the equipments, dresses, machines, device found connected or used, or after inspection of records maintained by any person, the assessing officer comes to the conclusion that such person is indulging in unauthorized use of electricity, he shall provisionally assess to the best of his judgment the electricity charges payable by such person or by any other person benefited by such use. The order of provisional assessment shall be served upon the person in occupation or possession or in charge of the place or premises in such manner as may be prescribed. The person on whom an order has been served under subsection 2 shall be entitled to file objection, if any, against the provisional assessment before the assessing officer, who shall, after affording a reasonable opportunity of hearing to the such person, pass a final order of assessment within 30 days from the date of service of such order of provisional assessment of the electricity charges payable by the such person. Any person served with the order of provisional assessment may accept.
Which
such
provision
assessment.
are you wanting me to read?
Hello.
Which particular provision are you stressing for?
Nothing, they have provided me lot any paper me lot at that time me lot when he read me lot.
The order of provisional assessment was not provided to
No,
you.
not me lot at that time me lot. And me
So
lot,
at what time was it
my lord,
provided? When was it provided? So that is for that criminal case has been registered.
My FIR has been registered, my lord.
So what is your prayer? वकील साहब को एंगेज नहीं किया है? वकील साहब को एंगेज किया है ना? नहीं, वकील साहब आप रहेंगे। वकील साहब को हमने एंगेज किया है, आपको इन पे विश्वास है तो इनको बहस करने दीजिए। अगर आपको नहीं है विश्वास तो हम आपको बुलाएंगे। दो जनों को बहस नहीं करने देंगे, या तो आप बहस कर लीजिए या वकील साहब कर लेंगे। Yes. What have you come against before this court?
That time, my lord, nothing was provided to petition, my lord.
You are praying for restoring of the electric connection. And
I am also filing supplementary affidavit, my lord, to quash the FIR, my lord.
For quashing of the FIR, you have not prayed in this petition.
I will file supplementary affidavit.
No, but that quashing would not come in this court, no? For that you will have to file a criminal writ petition, if I am not wrong. Right? And that goes before another forum. So you limit your arguments as to why the respondent should restore the electric connection. करिए बहस करिए, क्या कहना चाह रहे हैं?
And my lord, I have also filed counter affidavit, my lord. In that, my lord, I have stated, my lord, that the electricity department stated, my lord, that he was using buswire, my lord. Buswire, my lord. Buswire was, my lord, installed, my lord, after meter, my lord. And buswire was used only for dividing the connection, my lord. Annexure A1, my lord. Reply of counter affidavit, my lord. Annexure A1, my lord, page 18, my lord. I have annexed the photograph also, my lord. And thereafter, my lord, his two houses, my lord, about 100 meters away, my lord, that connection, electric connection has been also disconnected by the electricity department. Only on the reason, my lord, that this house belongs to the petition, my lord. No theft was in his house, my lord.
So after the reassessment, the final assessment order was of 3,60,165. So that has to be paid. Have you paid it or not?
No, I have not paid, my lord. The case is totally false, my lord.
If that is so, if you say that it is totally false,
my lord,
and the orders which have been passed by them are wrong, on the basis of wrong basis, then how can this court be examining them? Then go to civil court, challenge it, prove that the case is false.
Similar matter.
You will have to prove that it is a false.
Similar matter, my lord, this honorable court had twice this.
High Court said that case is false.
Same nature.
How come?
कौन सा केस कौन केस है क्या केस दिए जो है क्या नाम है पार्टी के आगे सिविल रेट में FIR तो उसमें है
यहाँ उन्होंने कहा है कि it is false. It said that the inspection report and provisional assessment order was not made available. Where is your contention that you were not given?
In the reply of the counter affidavit, we not para 5.
Where have you said that you have served him with a copy of the inspection report? And
My lord, come.
you have only said about final assessment.
My lord.
Where is that in your counter that you have said that you had given him interim assessment order?
My lord.
You have not supplied him inspection report.
My lord,
And in fact,
it is one annexer, my lord. Inspection report is FIR along with FIR, my lord. That is, my lord. Kindly come to page 20 of the writ application.
Yes.
My lord, it says, my lord.
This is in the FIR.
My lord, it is
The council that will not be providing the person.
My lord,
if you lodge an FIR in the police station and you say that you have served him an inspection report.
My lord, the inspection report along with the FIR at page 22.
But that is before the police authorities, na?
My lord.
In the FIR you have mentioned about the inspection report.
My lord.
How will the person know about it?
After, my lord, FIR.
And how could an FIR be registered when ultimately you found that it was less than 10 kV?
My lord.
See, he already had a authorized use of 10 kV.
My lord.
And ultimately, when you finally made your inspection, you found it to be 9.1.
My lord.
Less than 10. So how have you lodged an FIR?
My lord, for the simple my lord, that by passing the bus bar.
Where is that in the inspection report? Have you given him the opportunity?
My lord, it has stated in FIR itself, my lord.
Correct. You did not serve him a copy of inspection report?
That's why after that, my lord, she filed an objection before the Annex 2, my lord.
He has filed an objection that you have wrongly assessed the meter. And that is why you conducted a fresh assessment. And you found that the meter was only up to 9, the electricity.
The load was 9 kilowatt, but by
The
passing.
load was 9.1.
My lord.
There is you have initially said that the load which they were utilizing was 14.1.
My lord.
Later on, you finally came to conclusion it was only 9.1.
Maybe.
So it was less than 10.
Maybe, my lord.
So where is the criminal?
By passing the meter. By passing the meter is the offense, my lord, here.
See.
Passing, my lord, not permitting the meter to, my lord, even record the 9 kilowatt load, my lord. That is the FIR, my lord.
But then you should have given a copy of the inspection.
My lord, might have been given. I have not
taken your reply.
My lord, I have said only that she filed an objection with respect to, my lord, WhatsApp has been.
You have not come with a reply. You have not passed a provisional assessment order.
My lord, provisional assessment के बाद ही FIR में वो amount add होता है.
चलिए, let us see the FIR.
My lord, I'm just placing it, my lord. Page 20. My lord, second paragraph. After छापेमारी दल समय 15:45 बजे होटल रिजेंसी मालिक सूरज कुमार पिता सो एंड सो परिसर का जांच किया गया। जांचोपरांत पाया गया कि इनके परिसर में एक विद्युत संबंध लेखा संख्या सो एंड सो सूरज कुमार के नाम से स्वीकृत था। इस संबंध में अधिष्ठापित my lord at page 20, my lord.
Page
20. The written report submitted by, my lord, the assistant engineer, my lord.
एक विद्युत संबंध लेखा संख्या
सो जांच में पाया गया कि इनके द्वारा मीटर के पहले बस बार लगाकर सीधे बस बार से मीटर को बाईपास कर अपनी होटल एजेंसी में विद्युत ऊर्जा की चोरी कर रहे थे। छापामारी दल द्वारा इनके विद्युत संबंध विच्छेदित कर दिया गया। विद्युत मीटर के सभी सदस्यों द्वारा 4 अदद पेपर सील्स करके जब्त किया गया। जांच अवधि दिया जा रहा है, जिसे जब्ती सहजाज प्रतिवेदन के साथ दिया जा रहा है। परिसर के निरीक्षण के समय विनायक प्रकाश उपभोक्ता के पुत्र मौजूद थे। परिसर में कुल संयोजित भार इतना किलोवाट पाया गया और स्वीकृत भार 10 किलोवाट है। इस विद्युत चोरी से साउथ बिहार डिस्ट्रीब्यूशन कंपनी को 5,93,980 रुपए की क्षति हुई है और साथ ही उपभोक्ता को उतने ही राशि का लाभ हुआ है। अतः आपसे आग्रह है कि उपरोक्त अभियुक्त पर भारतीय विद्युत अधिनियम की 135 अन्य सुसंगत धाराओं के अधीन प्राथमिकी दर्ज कर कानूनी कार्रवाई करने की कृपा की जाए। So not by passing the meters, not even 9 kilowatt are allowed to be, my lord, recorded by the meter.
And then ultimately you found that it was total.
And thereafter, my lord,
which was being used was 9.3.
My lord.
Which was less than 10.
My lord, certainly. But it does not mean that no theft was there.
So that bus bar is the main reason.
My lord.
Where is that copy of that inquiry report given to him?
My lord.
The judgment says that you cannot proceed further unless you have given the copy of the inspection report. This judgment which he has handed over.
Cited, my lord. And all have been given, even the signature of consumer refused to sign, though it was inspection was made in presence of the son of the consumer.
23.
It has been written, but in my lord, he refused to sign, my lord. At page 23, if your lordship come, where?
So what is the objection which?
The objection is that she was not using 14 kilowatt, it is just 10 below 10 kilowatt. That they have constituted a committee, my lord, again inspected. Your lordship is aware that load can be, once it is assessed, whenever we go for the second time, load is not assessed that it is always fixed there. दोबारा जब हम नोटिस पर जाएंगे तो कम ही पाया जाएगा. इट इज नॉट दैट. The division bench of this honorable court, Ranchi bench, have in one case said what has been first inspection was found cannot be, my lord, taken in the subsequent. If subsequent, my lord, we have inspected that inspection load is on the date of inspection only. It is not, my lord, change the what has
the
been,
assessed load.
Yes, my lord.
Assessed load, which you have treated as 14.3.
My lord.
You have yourself reduced it to 9.3.
Yes, my lord. When we have second time inspected on his on her application, it was reduced. What has we have filed that we have recorded. It is not that on that first date it was not there. 14. तो यही डिवीजन बेंच का जो जजमेंट है हाई कोर्ट का, पटना हाई कोर्ट का, कि जो सब्सिक्वेंट जो इंस्पेक्शन होगा वो उस दिन के लोड के लिए होगा. इट कैन नॉट रेलिगेट बैक टू द अर्लियर लोड, माय लॉर्ड.
But that your final assessment is of 3 point. Have you deposited that amount?
My lord, he is not depositing that amount after even, my lord, the reduction of that load.
Why you not depositing?
Totally false FIR, my lord. Totally false FIR.
FIR false होते नहीं है.
False का है, आपने खुद ने कहा है कि इन्हें बना कर देने के लिए तो मैं उसका भुगतान समय पर कर सकूं. आपने खुद ने बोली ये बात. You yourself said. मुझे बोलने दिया जाए, प्लीज. प्लीज एक बार रिक्वेस्ट. आइए. इसको भी बोलने दीजिए.
लेटर. सरस्वती वर्धमान वही है जो भी आ रही हैं.
बोलिए.
Husband has not filed any application against the objection. His wife.
उस समय उनकी तबीयत खराब थी.
Yes.
मैं उनकी वाइफ हूँ, सूरज कुमार की वाइफ हूँ, सरस्वती बर्णवाल. मैंने ही सारा आवेदन दिया. मैं सारे तथ्यों से वाकिफ हूँ. असल में ऐसा है कि मेरे यहाँ बिजली चोरी नहीं हो रही थी. जिस समय ये टीम आई थी रेड करने के लिए, उस समय मेरे पति दीदारगंज में थे. तो मेरा एक स्टाफ था वहाँ, तो उन्होंने बात कराया कि मेरे यहाँ बिजली की कोई चोरी नहीं हो रही है, आप वहाँ पर रुकिए, मैं आता हूँ, मुझे आने में 1-1.5 घंटा लग जाएगा. तब तक मेरा घर बगल में ही, होटल के बगल में ही है. मैंने छोटे बेटे विनायक प्रकाश जो अभी RML में MBBS कर रहा है, मेरा बड़ा बेटा.
Don't give us a story about what you have done.
तो वो वहाँ पर
let us know what you want to say.
उसे वहाँ भेजे. लेकिन वो लोग आनंद फानन में उन लोग वो कोई कागज नहीं दिए. उस समय आनंद फानन में रनिंग और ओके मीटर को उखाड़ के वो लोग ले गए. कुछ बोले नहीं. मेरा बेटा पूछा कि क्या हुआ, लेकिन उन्होंने कहा कुछ नहीं जवाब दिया और वो लोग लेके चले गए. फिर 1-1.5 घंटे में मेरे जब हस्बैंड आए तो मैं खुद गई उनके साथ ऑफिस में, उनके ऑफिस. कहा कि नहीं मेरे यहाँ कुछ गलत नहीं हो रहा था, आपने मीटर क्यों उखाड़ा, वजह बताइए. उन्होंने कोई चीज नहीं कहा कि आप कुछ नहीं हो सकता है, आपका 1 पैसा भी कम नहीं होगा. उसके बाद तुरंत सेकंड डे 15 तारीख को हुआ था, 15/12/2021 को हुआ था. तो तुरंत हम नेक्स्ट डे, चूंकि शाम हो चुका था, तुरंत हम वो सिविल कोर्ट में एक सनहा किए कि मेरे यहाँ बिजली की कोई चोरी नहीं हो रही थी. और फिर तुरंत 17 तारीख को हमने विद्युत अधीक्षण अभियंता के यहाँ एक आवेदन दिया. आप देख लीजिए हुजूर कि उसमें भी हमने कहा कि मेरे यहाँ कोई विद्युत की चोरी नहीं हो रही थी. 17 तारीख को, 17/12/2021 को मैंने सारा कागज दिया हुआ था. 17/12/2021.
वो डॉक्यूमेंट ही नहीं आपका, तो 20/12 की एप्लीकेशन लगी.
तो जैसे मैंने सारा कागज दिया था हुजूर, लेकिन इन्होंने कहा कि हाई कोर्ट में ज्यादा नहीं दिया जाता.
Annexure 2 है लगा, 17/12/21 है लगा, है Annexure A2.
Annexure 2 is 20th of December. 20/12.
Annex counter reply of counter.
हम वहाँ
Annexure A2, page 20 to 34.
Yes. Yes, what do you have to say further? You Mr. Counsel, produce the inspection report. Original file of the Counsel for the Electricity Board shall produce the
मैं थोड़ा सा और बोलूं।
original inspection report.
मैंने बहुत बार दिया वहां ले जाके कि मैं मेरे यहाँ चोरी नहीं हो रही थी, लेकिन उन लोगों ने रिसीविंग नहीं किया दिया।
This again on 11th April.
Oblige me, Lord.
Next case.
Item 49.
चलिए हो गया।
Repeat case.
बहुत बहुत धन्यवाद।
Your Lordship, kindly pass the matter for tomorrow, Your Lordship.
Not for tomorrow.
Sometime, my lord, we have to file counter if instruction has not received, my lord.
Council wants time to file counter list after 4 weeks.
Oblige, my lord.
Item 50. Dr. Kulshekar.
लॉर्डशिप इसमें लर्नड एसी साहब भी आए थे, तो इसमें तो हमको 1 सप्ताह के लिए हुजूर समय का ये था विद काउंसिल।
AG साहब है? Where is AG in this case? What is the issue involved?
लॉर्डशिप ये रेलवे से संबंधित मैटर है, पिटिशनर इज कॉन्ट्रैक्टर लॉर्डशिप।
Yes, you were making a mention in the morning also, na?
Lordship.
What are these IAs for?
IA for Lordship है vacating the order dated 30/1/2023 Lordship, filed by railway respondent Lordship. उसमें काउंटर लॉर्डशिप हमको लेट से मिला, तो पर्सनल डिफिकल्टी था, हमको बस बाय दिस वीक लॉर्डशिप हम फाइल कर देंगे, 2 दिन भी दिया जाए तो हम फाइल कर देंगे। रिप्लाई
2 क्या है?
एक आईए हम फाइल हुआ है रेलवे तरफ से और एक काउंटर एफिडेविट फाइल हुआ है।
Counsel for the petitioner wants time to file a reply to the counter affidavit and to the IAs.
Lords.
List again after 2 weeks, interim order to continue.
Lords. Not allowed.
Item 51. Mr. Abhishek Anand.
Lordship, this case involves cancellation of a BDS holder license. Order of the commissioner is under challenge. Counter affidavit has been filed in this case, and counter is supporting me. So there is no need to file rejoinder. The order of the commissioner is at page number 20. May I read the order with your Lordship's permission?
Yes, yes.
प्रस्तुतवाद श्री कमलेश कुमार यादव, who is a private respondent over here, के द्वारा माननीय उच्च न्यायालय पटना का CWJC
operative part. Come to the part.
Operative part is the third para,
of which you are agreed of.
Fourth para, Lordship. प्रतिवादी संख्या 4 रूही गजाला पति असगर आलम खान को नोटिस भेजे जाने के बावजूद उपस्थित नहीं हुई। That I will explain, Lordship. अनुमंडल पदाधिकारी शेरघाटी पत्रांक द्वारा प्रत्युत्तर दाखिल किया। अनुमंडल पदाधिकारी शेरघाटी के प्रत्युत्तर का अवलोकन किया गया। अनुमंडल पदाधिकारी शेरघाटी के द्वारा बताया गया कि संबंधित जन वितरण प्रणाली चयन हेतु आरक्षण रोस्टर नंबर 715 प्रशासन विभाग द्वारा जारी आदर्श मॉडल रोस्टर के अनुसार अनरक्षित महिला अभ्यर्थी के लिए आरक्षित था, किंतु कंप्यूटर ऑपरेटर की गलती से विज्ञापन में सिर्फ अनरक्षित प्रकाशित हो गया। That is the mistake which they have done, and they are admitting in their counter affidavit. I'll again continue. लेकिन संबंधित आरक्षण बिंदु अनरक्षित महिला के लिए आरक्षित होने के कारण चयन समिति के द्वारा अनरक्षित महिला उम्मीदवार पति संख्या 4 रूही गजाला, who is the petitioner over here, का चयन किया गया। Very small issue, Lordship. Next para. संपूर्ण तथ्यों की समीक्षा की गई। यह सही है कि आदर्श मॉडल रोस्टर के अनुसार आरक्षण बिंदु 715 अनरक्षित श्रेणी की महिला के लिए आरक्षित है, किंतु विज्ञापन में अनरक्षित श्रेणी के प्रकाशन होने के कारण पूरी चयन प्रक्रिया त्रुटिपूर्ण हो जाती है। अतः रोस्टर 715 के चयन को रद्द किया जाता है। अनुमंडल पदाधिकारी को निर्देश किया जाता है कि संबंधित आरक्षण रोस्टर बिंदु 715 में पुनः संशोधित विज्ञापन प्रकाशित किया है, जिसमें आरक्षण कोटि को छोड़ अन्य सभी शर्तों के विज्ञापन अनुसार रहेगी। इसी के साथ इस वक्त की कार्रवाई समाप्त की जाती है। आदेश की प्रति जिला पदाधिकारी को भेजिए। They have admitted in their counter affidavit. Computer operator mistake. No fault on mine.
Want to file your reply?
Yes, my lord, you have filed probably that has come for this record because very shortly that has
Counsel
online.
The respondent states that they have filed their counter. List this case again. After 2 weeks. In the meanwhile, the respondents are restrained from acting upon the order passed by the Commissioner dated 8/12/22.
बना दीजिए सर।
Item 52 with analogous text. Mr. Avdesh Kumar.
My lord, in this case, my lord, in this case, Railway Council, Mr. Priyanka Kumari, my lord, had told me that it will take password for today only.
After lunch? After lunch break आ जाएंगे वो?
नहीं, मुझे आज होल डे के लिए कहीं पास हुआ, हमको प्रॉब्लम होता जा रहा है।
Petitioners Council.
हाँ डॉक्टर हाँ सर।
Petitioner Council in CWJC 172232 of 22 took time to file a rejoinder to the counter affidavit.
Yes, Lordship, I am appearing, and Lords, today I am filing. The file has been ready, Lords, to reply to the counter, and that is being filed, Lords. That is why.
There are two connected cases.
Yes.
Yes.
Same type.
Yes, Lords.
I am not. I am in the CW 17223, Your Lordship.
Who's there in the other one?
17393 connected. Same.
देखिए ना, चेक करके बताइए whether they are the same. We would.
Your Lordship, he is going to file as he submitted.
Just check out that file whether
Okay.
they are the same prayer. You remember?
There are three.
There are three of them.
Yes.
So who?
My case is different, my lord. In this case, my lord, as per decision of this honorable court, without assessment.
You are in which case?
My lord, 52, serial number
52. So
Yeah.
argue your case.
Yes, my lord. But रेलवे काउंसिल जो है से कही कि पासवर्ड ले लीजिए, क्या कहा है, लास्ट डेट पर भी यही कही।
You filed a counter in this case?
No, my lord, it is fully covered by the division bench of this court order, my lord.
Have you filed your counter in
Yes,
this
your
case?
lordship. I have filed.
In which case?
In
527.
393. 17.
527 सबसे पहले 527 लगा हुआ है।
वो तो इनका है।
ओहो, इसी में तो पूछ रहे हैं कौन है इसमें?
प्रियंका कुमारी है, my lord.
रिट का कॉपी।
उन्होंने काउंटर नहीं फाइल किया।
हाँ, डिवीजन में
रिट का कॉपी इसमें का काउंटर फाइल हुआ है कि नहीं?
नहीं, काउंटर नहीं।
नहीं, नो काउंटर।
काउंटर भी फाइल 3 weeks.
My lord, in the meantime, status को दे दिया जाए।
नेक्स्ट केस दिखाइए।
My lord, my lord. In the meantime, status को railway removing my stall on the platform, my lord, forcibly. In spite of fact that I have already deposited.
In the meanwhile, status quo shall be maintained.
Obliged.
दूसरा 2 cases में भी सेम?
No, your lordship.
Lords, I am
There
appearing.
is a status quo order in the next case also.
Lords,
17223.
In this case, Lords, status quo is also there, Lords.
That is there. You have filed your counter?
Yes, your lordship, in 17393.
The counter has been filed, tag along with list again, along with item number 52. Sorry.
And Lords,
तीसरा. And who is in BH catering?
I am appearing the repetition. This case, the counter has been filed, your
Your lordship, in this case, the petitioner has challenged the same thing which has already been decided by this honorable court.
and this has been disposed of. In light, arbitrator has been appointed, your lordship, and arbitrator appointed कर दिया गया हुजूर, as per direction of this honorable court. In the I have written in the paragraph, kindly see your lordship. Kindly seek pay our counter affidavit pay para 13.
इस कोर्ट में कोई डायरेक्शन तो है नहीं इसमें?
इसमें हुजूर CWJC 7464 2022 ये फाइल पहले भी किए थे. That has been disposed of to take and pass an speaking order. Then speaking order has been passed, and that has been challenged, your lordship. Paragraph 13 of my counter.
My lord, I have in the other two also there is a clause for arbitration.
Your lordship, all three matters are different. I don't know why it has been tagged together. Because mine.
You are in which case?
I am in CWJC 17223.
All right.
In which my friend wants to file a rejoinder, which is going to file today.
All because this is regarding but there is no arbitration clause in those.
There must be. There must be.
Then you tell us on the next date.
Yes.
So if there is an arbitration clause, go there.
My lord, arbitration has been going on.
Going on.
And I come before this court.
So you withdraw this petition if there is already an arbitration clause, and you are already there before the arbitrator. Counsel prays to withdraw the petition, as it is informed that the matter has already been taken up by the arbitrator. That petition is dismissed as withdrawn.
Lords, in CWJC number 17.
आपका केस में भी arbitration clause है?
नहीं, इसमें arbitration clause नहीं.
नहीं होगा.
हमने हुजूर एग्रीमेंट लगा.
दोनों केसेस की डेट दे दो. 5 तारीख 5th.
हुजूर इस बीच में वो स्टेटस को कंटिन्यू कर.
Interim order to continue. चलिए नेक्स्ट केस बताइए.
Item 53, Mr. Amren Narayan Rai.
By last order dated 23/2/23, respondents were directed to file counter affidavit, but till date
They have not filed?
They have not filed counter
As
affidavit.
the last opportunity, 3 weeks time is granted to file counter affidavit. List after, thereafter.
Item 54 is not available.
Item 55.
Lordship, matter has been settled by way of the compromise and OTS schemes. The matter related to 2013, now 2017, the no due certificate has already been issued.
No.
Yeah?
No due certificate has not been given by the bank.
What is your case?
Case, I have applied for an educational loan, my lord.
Yes.
And you are here for what?
Here, after settlement in the compromise before the Lok Adalat, and are receiving all the money of rupees 4 lakhs on which has been paid by the petitioner on 17/3/2013. On thereafter on 26/3.
So you have a no due certificate lying with you?
Yeah.
You have a copy of the no due certificate issued to you?
No due यहाँ तो नहीं है.
You have a copy of that no due certificate with you?
ये 17th नहीं, अभी इसमें यहाँ तो नहीं, लेकिन
आप अभी ये बात कह रहे थे.
जी हाँ, ब्रांच में इसको फाइल में इनका अब रिसीव किए हैं कि नहीं, तो बिकॉज
तो आप लेकर आते ना यहाँ पे.
इसमें जो 2017 को ऑलरेडी कंप्रोमाइज.
For the petitioners, for the respondent states that no due certificate has already been issued. And a compromise has also been arrived.
Yes.
Let him place the same on record. List this case again on 3rd April.
All right. Bye.
Item number.
Petitioner challenges, no one appears even in the second round. Petitioner challenges the notice. Dated 19/8/22. Issued to him by the respondent. Under Section 32 of the Surface Act 2002. The petitioner has already submitted objections to the said notice. The respondents are obliged to take a decision thereto. If any further proceedings are initiated, the petitioner has an efficacious remedy of taking up the matter before the concerned DRT. Stop. In terms of the judgment passed by the Supreme Court in Travancore versus Swenson, Bank of Travancore, the writ petition is held to be not maintainable, is accordingly dismissed.
Item 20. Mr. Sasi Bhushan Singh.
Reply verified. Reply verified.
Item 43. With analogous case.
Got your file?
Yes, ma'am.
Because I don't find it here.
I have it.
Ready? Okay.
My lord.
वो वाला फाइल दे.
Lord CW 10247 filed by the bank, which the award, which is at annexure 1, page 28, is under challenge. Now what has happened is, my lord, that 13 persons who claim to be daily wage messengers of the bank, that was their claim, they had raised a dispute challenging that they have been illegally terminated or retrenched with effect from 2/6/2007 without compliance of Section 25F, and that is why they went and raised a dispute against the bank, and the matter was referred to the Central Government Industrial Tribunal number 1 Dhanbad for adjudication. Now, if your lordship will kindly come to annexure 1, page 28, the terms of reference which was referred to the tribunal has been quoted by the learned tribunal, and your lordship will see that the names of 13 persons are mentioned on the very first page where the terms of reference has been quoted, that these are the 13 persons with regard to whom the case has been referred. Their names are clearly mentioned. Now, the finding which the court has arrived at
is that these persons were terminated in violation of section 25F. And if your lordship will come to page where the relief has been granted, page 47, page 73, paragraph 46 and onwards, I'll demonstrate how the findings are wrong. The labor court says that they had worked for 240 days in a calendar year.
Up to page 41.
Yes.
Internal page 41. Page 68.
Page?
Para 48.
Para 48? Yes, my lord. After considering all the facts and circumstances, the tribunal rendering the...
Now in this case?
That's para 48 of the award.
Oh.
That is at page 73 of the report.
This is wrongly mentioned as para 48. I think it should be para 39.
39.
Before para 40.
Just a moment.
Now in this case, you see they mentioned 48 para.
Award ka page 40.
Internal page 41.
Internal page 40. Just a moment. Yes, my lord. Now, in this case, there is categorical evidence that all the 13 concerned workmen had rendered in Patna Secretariat branch of SBI more than 240 days in each and every calendar year. So the concerned workmen were in continuous service in the bank as per definition of 25B. Moreover, there is also evidence that the concerned workmen were removed from his service with effect from 2/6/2007. Further, there is no evidence before the tribunal that the concerned workmen have been given 1 month notice and so and so, indicating reasons for the retrenchment, removal, and had been paid compensation equivalent to 15 days of average pay as per the provisions of the 25F of the IDA. Now, this is at one place where the tribunal has observed like this. Then further, it has also observed in subsequent paragraphs. If your lordship will kindly come to paragraph 46 at page 73, reiterating more or less the similar view. Page 73 of the writ, internal page 46 of award, paragraph 46. Now, in this case, all 30 concerned workmen, so and so, so and so, so and so, and so and so, have been working as messenger, and Satinder Singh has been working as electrician on daily wages in the State Bank of India, Patna Secretarial branch since their appointment on different dates. And they were removed from the service with effect from 2/6/2007 without being given any notice of retrenchment. Then further it says, in view of the decision of the Honorable Supreme Court as discussed above, it would be proper, just and reasonable to grant lump sum monetary compensation of 3 lakhs to all the concerned workmen. After considering all the facts and circumstances, the tribunal renders the following award. And then it holds that the action of the management of SBI in terminating the services of so and so is not legal and justified. Hence, the concerned workmen are entitled for relief, which is as under. The State Bank of India Patna Secretariat branch is directed to pay a sum of 3 lakhs to each of the 13 concerned workmen, namely so and so, so and so, so and so, as lump sum compensation after proper verification within 1 month and after publication of the award. Now, your lordship, there is a factual backdrop to this case, which I want to bring it to your lordship's kind notice. Now, the dispute regarding these 13 persons, the dispute regarding these 13 persons was referred by notification.
What is your argument?
The argument is that this is the second round of litigation that is taking place before this honorable court. In the first round, an award had been passed in favor of these 13 persons, giving them relief of reinstatement, which was challenged by the bank before this honorable court. And this honorable court gave several findings in the order and remitted the matter back to the tribunal to pass a fresh award. No further evidences would be collected, no further materials. Whatever is available on record based on that, both the parties were asked, you go in advance, make your written submissions, make your arguments before the court, and a fresh award will be passed. And this is pursuant to that this fresh award has been passed. Now there are some
Did it commit any illegality?
Yes, that's what.
Did it record any further evidence?
No, it did not.
Then?
No, I'll demonstrate. There were certain very important observations made in the earlier order of the Honorable High Court. I just want to briefly show
Did
some.
the court say that you will follow our observations and pass it on?
No, the court said in the very first.
Or it just directed that we remand it back and you pass a fresh
it
award.
remanded back in light of those observations, pointing out the infirmities in the award and the illegalities in the earlier award.
So earlier award was set aside on the basis of those observations.
It was set aside.
Did it say that our observations shall be followed for the purpose of
My lord, I'll just take cursorily through some of the important observations. Yes, madam. That is at annexure 12, page 281.
So it is your case that they have not followed earlier.
Some of the observations and findings of the previous order have not been properly followed by the tribunal. So that order is at annexure 12, page 281 of our writ application. Now, the important paragraphs which I just want.
All right, any other argument?
No, that apart. Now, the court had observed that the court has failed to give a finding that the workers have worked for 240 days in 12 calendar months immediately preceding the date of termination, which is the requirement of law. That has to be done. Then another important finding that was observation that was given in paragraph 14, page 281, your lordship will kindly see. Now, paragraph 14 of this order, previous order passed by this Honorable High Court, had given the observation that although the reference was in respect of 13 persons, only 8 had turned up to contest the case. 5 of them did not turn up to contest the case, did not give evidence also. And the persons who did not turn up, their names were clearly mentioned. People who turned up, their names are also clearly mentioned in paragraph 14 of that order of the Honorable High Court. If your lordship will kindly see paragraph 14 of the previous order. I'm just reading that part. It would be manifest from the record that out of 13 persons, only 8, namely so-and-so, 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 and so-and-so, contested the reference case by giving their evidence. The others did not turn up to contest the case. But the tribunal has granted relief of reinstatement to even those respondents who never contested the case.
All right.
Now again, the relief has been granted to all the other 5 persons also who never turned up to contest the case. And strangely, this has been done after the tribunal has itself, in the current award which is under challenge, the tribunal in paragraph 26 of the impugned award has itself noticed and commented on this. I'm just placing paragraph 26 of the impugned award. Which is at page 53 of the writ application. The award under challenge. Paragraph 26. Page 53 of the writ application, internal page 26 of the award, paragraph 26. I'm reading paragraph 26. At the outset of discussion, it is required to mention here that in this case, the Ministry of Labour and Employment, Government of India has referred the matter with regard to 13 workmen, but the sponsoring union has examined only 9 witnesses, out of which the name of WW9 Shiv Bachchan Prasad is not figured in the list of referred workmen. So only 8 effectively. And in this way, the concerned workmen, namely Rabindra Kumar, Nand Kishore Ram, Ajay Prasad Srivastav, Sunil Kumar and Arjun Kumar Singh were not examined before the tribunal. Moreover, no explanation has been given by the respondent union about the reasons for their not examination.
What do you want to say?
So the point that I'm trying to make for your lordship's kind consideration is the persons who did not even turn up to contest the case and give their evidence in support of the case relief, first of all, could not have been granted to those 5 persons.
Why?
Because they didn't turn up to contest and present their case.
The union is representing them.
Union was there.
But union is representing them. That is not denied by you.
No, union is representing, only one person came from the union. Now the question
Who
is,
comes from the union? We want to know from you whether it was being represented through a union or not.
it was, the union came.
Now let us know if the reference is made for 30 persons. Can the court answer only for 8 persons?
The court will answer, and with regard to persons who didn't turn up to plead and present their case or give their evidence, the court.
But if your evidence is sufficient to show your witness evidence is for all 13, no?
My witness, we actually denied that these are not employees of the bank. They were working through some contractor over there in the bank.
But you mentioned about all 13 persons were working through the
All 13 persons were working through some messenger. They were never employees of the bank. But now another thing is that the law is very well settled that even if assuming for the sake of argument that I say that they were working as messengers on as and when required basis on daily wages with the bank.
Yes.
The law says that in order to attract section 25F of the ID Act, which I have understood up till now, Lordship, is that what is important is for them to demonstrate that they had worked for 240 days in the 12 calendar months immediately preceding their termination. Even if they say that हम 10 साल पहले से काम कर रहे थे, but if you have worked intermittently, sporadically, at different periods, which the tribunal has observed, that they did not, there is no finding by the tribunal that they worked continuously. The tribunal says they worked on as and when required basis at different periods.
Come to that.
Yes, my lord. I will, if my lord will kindly come to paragraph 35 and 46 on this. Let us first see paragraph 35 of the award. At page 63 of writ application, internal page 36. May I place it, my lord?
From para 35 onwards?
Yes, 35. No. Now, after analyzing oral and documentary evidence of both the parties as available in report, it is quite apparent that there is a consistent evidence that the concerned workmen, namely so-and-so, were employed with SBI Patna branch as messenger for discharging different works in banks, and workman Satyendra Singh was employed as electrician on casual basis daily wages for electrician maintenance. Moreover, exhibits W2 series, 4 series, 5 series, 6 series, 7 series, 10 series, 11 series, 12 series, 13 and 17 and 20 show that all the concerned workmen have been paid their remuneration for their work in the bank at different periods. And after computing the period of payment, it appears they had worked for 240 days in one calendar year. Now, which calendar year? It is not making an observation and finding that they had worked for and they had been removed from their service on 2/6/2007. Further, it is quite apparent that the management of SBI in their WS has admitted that all the concerned workmen were working on basis of as and when required. Now, if your lordship will kindly come to paragraph 46. Just a moment. (46) at page 73 of writ, internal page 46 of the award. Now in this case, all 13 concerned workmen, so-and-so, so-and-so, and so-and-so, had been working as messenger, and Satyendra had been working as electrician on daily wages in SBI, Patna Secretariat branch since their appointment or different, and they were removed from their services on 2/6/2007 without being given any notice of retrenchment. So again, the finding is that on different dates they have worked.
Yes.
Now there is no finding.
They have worked on different dates,
It's saying 46 itself, last third line. The electrician daily wages in SBI Patna since their appointment.
Their appointments on different
days.
Appointments are on different days.
No, appointment is there, but they have worked on different dates on as and when required basis, which is
he has reached to a finding that they have worked continuously.
No, they haven't.
This is what the finding is.
No, my lords.
Were in continuous, they have defined. Come to page 41. I asked you to read that.
Yes, I read that, my lords. Paragraph.
That's the finding of fact.
Page 30, paragraph 38 makes it very, very clear.
Definition of 25B as discussed. And after that,
I'll come to that.
Conclusion.
I'll come to the paragraph definition of 25B in light of.
Show from your reply to the statement of claim that they were worked on different dates.
No, I have said that they have not worked.
So from your reply to the statement of claim.
Lord, so I'll place that as well. Just one paragraph.
Your affidavit must be there, no?
Yes, madam. Yes,
so
madam.
come to that. You have made such a voluminous file.
No, my lord. We have said that they have never been the employees of the bank and they have never worked for 240 days.
Sure.
Just a moment, your madam. Page 103 is the management WS. Paragraph page 109, paragraph 17 of our written statement, which was filed before the tribunal.
Come to page 146 of your file.
Yes, ma'am.
The affidavit and cross-examination of your witness.
My lord. Yes, my lord. Work for less than 240 days in one calendar year.
Work for no, I have not seen any record that was concerned. That the workmen concerned were worked for less than 240 days.
My lord, may I humbly submit for your lordship?
Counsel, please don't read like this.
No, my lords, may I humbly submit the law which I have understood. I may have wrongly understood. What I'm saying is...
Come to the law later on, come on the facts first.
The fact says the management took a clear-cut stand that they have
That's
not...
That's why we are asking you to read your witness.
One witness may say that one witness may say that perhaps I have not seen the record whether they have less than 240 days.
We will not let you do this in the court. You just said work for less than 240 days. He says that I have not seen any record that the workmen concerned work for less than 240 days.
Did they produce the document?
Doesn't it give a different meaning?
No. Did the employees establish?
Doesn't it give a different meaning?
Does it give a meaning that he worked for?
कुछ भी गलत कोर्ट के अंदर थोड़ी मत बोलिए. You are not going to
my lord, I would be the last person.
You said so.
No, my lord. I'm simply saying that the bank management bank took this stand that they have not worked for 240 days.
ये तो बड़ा मुश्किल है सर.
And they failed to produce. No, my lords, they failed to produce any evidence to prove that they had worked for 240 in 12 calendar months. That is the whole question over here.
You took a stand that they have said that they have continuously worked, and there is a finding given by him. Now you say that the finding is purpose.
Now the thing.
Your finding is purpose. Then we will look into your witness. Huh?
Now the thing is the finding should have been they should have produced evidence to show only one thing, that just 12 months preceding 2/6/2007 they have worked for 240 days. That's it for attracting 25F. No evidence has come on that aspect, and there is no finding of the tribunal on this aspect. And not one, but your lordship must be aware, I mean, your lordship is aware that there are a series of judgment on this issue saying that it is the onus is on the workmen, not on the management, to prove that they have worked for 240 days in 12 calendar months. That is something which they should have discharged before the tribunal.
Your entire stand in cross-examination changed. Your stand, which you said that we had taken by way of contractor.
Yes.
See what he says, your witness, in page 146. The next line. You don't want to read it, or you want to read only one part of it?
But I'm not pressing that part in the writ application.
It is your stand which you have taken. You said they were appointed to contractors. Now you say, I do not know that the branch manager who engaged the workmen concerned illegally was proceeded with or not. So now your stand is that the branch manager engaged them.
No, what we submitted before the tribunal, let me make it very, very clear, is that these persons were not engaged by a normal recruitment process which is followed by the bank. So branch manager at local levels, what they are doing is that through some petty contractors, they are engaging these kind of people, which they should not be doing, but that is what they are doing. They were not recruited following a recruitment procedure of the bank. So they were not regular employees. Now it is a very common thing, that is what is happening at local levels in different branches, is that the branch manager at his own level is engaging.
Any other evidence?
No,
apart from this witness number 1 on your behalf. No.
I was simply showing just a couple of points before, my lord. If it pleases my lord, then my lord will take notice of it, or otherwise. Number one point that I'm raising is that there is no finding given by the tribunal that they worked for 240 days in 12 calendar months.
Please come to exhibit W2 series. What is W2 series?
My lord, page?
We don't know. There's a part where in the award it says that moreover exhibit W2 series. Come to page 37. The finding which he has arrived at is based on some
page
exhibits.
My lord's page 37. I'm not contesting before your lordship in the writ application, this writ application, neither.
The finding which he has arrived at is on the basis that.
Am I submitting? I know there are certain weaknesses of the bank in which they have gone about taking services from these people. What I'm simply submitting is, I'm not pressing those aspects. I'm simply saying that the matter was remitted back, saying that please give a finding and please decide whether they worked for 240 days in 12 calendar months.
What he has said in page 37, Mr. Counsel.
My lords, there is no specific finding that in 12 months preceding the termination.
Anything else?
That is one aspect, my lords. And on that, I just wanted to share one judgment with your lordship, if your lordship will permit me. And then there are other points that also I just would like to raise.
Finish off quickly. You are in the admission stage. It's a fresh admission matter.
Yes, my lords.
Are you on merits?
I'm arguing on merits itself.
Please. What are your other points? Please tell us.
Yes, my lords. I will come to other points as well. Now, there is another aspect that we had brought it to the notice of the learned tribunal before the EJIT. Apart from this 240 thing, and the point that the persons who didn't turn up shouldn't have been granted the relief, who didn't turn up to contest the case, they shouldn't have been granted the relief. We had raised the issue before the tribunal with regard to the correctness and validity of the corrigendum notification based on which this entire adjudication has taken place. Now, what has happened in this case was, earlier the first reference was made by a notification dated 17/1/2011, in which is at annexure 3, page 88, in which the dispute of regularization of these persons were referred. Now, when that matter was pending before the tribunal, a corrigendum was issued by the state government saying that the word regularization was removed and the word termination was included. Now, this corrigendum, we raised an issue before the tribunal. We made a written submission when the matter was remanded back as well, that this tantamounts to revoking and cancelling the previous order of reference, which is not permitted, and the government doesn't have the power to do that. Because it tantamounts to superseding the previous reference, because the relief which could have been granted by the first notification of reference can't be granted now. Now, if your Lordship will kindly see the first notification and the second notification first. The first notification is Annexure 3, page 88. Whether the action of the management of SBI in not regularizing the services of 13 workmen listed below is legal and justified, to what relief the workmen are entitled to. Then thereafter, a corrigendum was issued, which is at page 92. If your Lordship will kindly turn to page 92. The terms of
just a moment. We could not get the first term.
The first
at
one
page
is
88.
Page 88, if your Lordship will kindly.
All right.
So first, the reference was with regard to the subject matter of regularization. But during the pendency of this reference, a corrigendum was issued, which is at page 92.
Yes.
And by this, the entire thing was.
The earlier one where you have written by hand, someone has written.
No, that is the court which has written it, my lords. We have not, because the court has made that noting.
He has made a noting that these corrections are required to be made.
Exactly, so that he doesn't forget that it
No,
has
no,
been.
no. He seems to have made noting and then refers to the corrigendum dated 18/3/2011.
Correct. What is
and
noting?
That,
the first notification is 17/1/2011 and the corrigendum is 39/2011. And the regularization was totally removed and termination was added. Now, the legal question that rose for the consideration of the learned tribunal, which we raised it when we before the tribunal, was that this corrigendum amounts to revoking or superseding the previous reference, because now the relief which could have been granted, the subject matter has been completely changed from regularization to termination. And in view of the law settled by this honorable court in a leading judgment way back in 1958 itself, I think so, that said that the government, while exercising power under section 10 of the ID Act, doesn't have the implied or express power to revoke, cancel, supersede a previous reference.
has this been done? Have they revoked, cancelled?
This tantamounts to.
The correction can also not be done.
No, now the subsequent judgments have come, whereby they make it clear, the other high courts have also made it clear, that if there is some clerical error, typing error, etc., it can definitely be corrected by a corrigendum. The judgment has also come to the extent that if there is a reference and that needs to be amplified or some additions need to be done, that can also be done. That can also be done. But something which can't be done by way of corrigendum is that you take away the subject matter of the previous one, meaning thereby the test which has been laid down by one of the judgments of one of the high courts is the test to judge as to whether it tantamounts to revoking the previous one is.
How was that aspect dealt with earlier?
Not dealt with at all.
Took up the issue in the earlier.
Even in the earlier writ, we had raised.
Then
it.
what did the court say?
All go and raise your submissions before the court. Go and file. We went and filed.
Show that the court allowed you to raise that objection.
My lord, no, my lord, they said go and make your arguments, and we had originally also raised it.
Where is that? That's
my lord.
Whether the High Court in its in your first round of challenging the.
My lord, I'll just annexure 12, page 281. Before passing the record, the tribunal shall give opportunity of hearing to the parties on the basis of materials on record. This is the previous order passed by the Honorable High Court.
Yeah, where is that taken? Where is the ground taken? See, he has quoted the original reference and the subsequent reference, corrigendum.
Correct. And
your argument is not there that the corrigendum could not have been looked into. Then there was no occasion of remanding the matter back.
My lord will see the supplementary affidavit which have been brought on record.
And counsel, if this argument would have been taken and accepted by the court, there was no occasion to send the matter back.
No, my lords, the point that was raised in the previous writ application also, and they said
that was raised.
The court said go and raise your.
In your favor.
No, my lord, the court said go and raise your submissions before the.
Doesn't say so that additional other grounds shall be taken.
Additional, no, it doesn't say additional. It says make your submissions before the court below, and we appeared and we filed a written submission, which my lord will find as annexure 13 to the supplementary affidavit. And my lord, this is a question of legality and jurisdiction of the tribunal.
So you can raise it one after the other.
No, my lord, that has not been the endeavor. The endeavor is just to show that what has been done by the state government is something which is not within.
Have you raised it? And if you have not raised it,
my lord will kindly come to annexure 13, page 7.
Please show anywhere any indication in the judgment where the court has noticed your argument.
No, I think that has also been noticed somewhere, my lord. Just a minute.
And has said that you can raise it there.
My lord, just a minute. My lord, it has, the argument was noticed, if I correctly remember. My lord, just a minute, my lord. My lord's paragraph 13 of the judgment, my lord.
Yes.
13 of the judgment. At page 291 of the writ application, my lord. As stated above, the first reference was made by the order of reference dated 17/1/2011, and the same was with respect to the subject matter of regularization. Subsequently, by another order of reference dated 39/2011, a corrigendum was issued amending the previous terms of reference, and the subject matter of the dispute was drastically changed from regularization to termination.
All right. Then.
So this has been noticed by the Honorable High Court in the first round, and that is why when we appeared before the learned tribunal, we.
But where has he?
We amplified.
He said that the second reference is bad.
No, I'm not saying that he said that the second reference. The matter had to be decided by the tribunal. We appeared. No, this, my lord, this will not require evidence. This is a matter, pure question of law. It is for the tribunal itself to notice that first notification, second notification, and the case laws. We filed all the case laws also before the learned tribunal. If my lord will see annexure 30.
This is one of your arguments. Anything else?
My lord, we'll just have a look at annexure 13 at page 7 of the supplementary affidavit. And if my lord will kindly come to page 8, objection which is at B. B.
All right, we take it that you have raised an argument.
Yes. We raised it, we laid down all the judgments, and we also submitted the copies of the judgments before the tribunal. Our only grievance, limited grievance at this point of time is this aspect has not been dealt with by the learned tribunal at all. The learned tribunal has sidestepped this issue and has decided on all other things, but not on the issue of the correctness or validity of the corrigendum notification as to whether it was correct or not, whether the government rightly issued it, whether it tantamounted to superseding the previous reference or not. There is no discussion and there is no finding on this aspect of the matter. So the only issues that we have raised, just to sum up the argument, is number one, people who didn't turn up to contest the case ought not to have been granted the relief. Number two, that the onus was on the workmen, and the Supreme Court judgment, Your Lordship, is there. That makes it very, very clear that the onus was on them to prove 240 in 12 calendar months preceding the termination, not from when you came into employment and worked at different periods. That is not relevant. The last 12 months preceding the date of...
That was already noticed in the earlier judgment, that the onus is on them.
The onus is on them.
And
that has been the consistent view of the Honorable Supreme Court also. And in this judgment, which we are relying upon, the Supreme Court makes it very clear. And they say what is important is the last 12 months preceding the date of termination. Because in this case also the worker said, we have been working for last 10 years. So that is there, that paragraph 19 of the judgment, if Your Lordship could kindly take notice of that. And the another thing is that the notification part of it was corrigendum.
What do you have to say?
This is all that I have to say. Submit, Your Lordship.
I am only placing for the enhancement of the lump sum amount which has been granted by the tribunal.
And my lord, just my lord, the last submission would be that even if Your Lordship is not convinced and Your Lordship agrees with whatever has been, our submission was that the compensation alternative argument is too excessive, because there is no finding that they have worked continuously for 9 or 10 years. So 3 lakhs per person is slightly excessive. So, I mean, that is for Your Lordship's kind of consideration.
Our case was that the workman was employed through the bank and they have been continuously working. They were not regularized.
Your petition is for reinstatement and continuity or
enhancement of the claim, my lord. Enhancement of the lump sum payment.
That is what you have prayed for?
Yes, my lord. One of the prayers, my lord. I am only pressing that as of now, my lord.
You asked for reinstatement.
Prayer number 3. At this, Lord, the predicament is that during the course of trial, the entire petitioners have reached the age of superannuation.
Okay.
So I'm just pressing for enhancement of the claim.
You are pressing for prayer number 3 only?
Yes.
All right. What is the ground?
Lord, may kindly see the supplementary which I have filed. I have provided the service tenure of the each workman, my lord. Or page number 2, my lord, of supplementary, my lord. I provided a tabular chart to show that they have worked ranging from 7 to 23 years. And they have fought for more than 10 years of long trial, and they have been given 3 lakhs. But also I have placed the order of Honorable Apex Court, wherein in 2015 itself, in absolutely similar case, 5 lakhs was awarded by the Honorable Apex Court.
All right. Where is your chart?
Supplementary affidavit in CWJC number 18774.
Chart at which page?
Page number 2, my lord.
Yes. What have you done this calculation, 25,000 per service per year?
Yes, my lord. During the course of hearing, Honorable Court directed me to provide a tabular form wherein the court wanted me to calculate as per 25,000 per years of service for the assistance of the court. I have done that. However, my lord, I was only pressing for enhancement of the claim till 5 lakhs to each of the workmen.
We have denied this in our reply.
All right. Anything you want to say?
We have replied to this.
Kindly see the page number 5 of the supplementary. I have placed a order from the Honorable Apex Court.
That is it. Anything else?
The thrust of the argument of the management is that we were employed through a contractor. By order dated 21st December 2022, Honorable Court asked that the management to produce the original agreement. It has not been produced, my lord.
It's there on record.
The original agreement has not.
Affidavit has been filed.
Court asked means the labor court or here?
Honorable Court. This one.
All right.
This has not been. The case is, my lord, there was no contractor only. It was only the camouflage that was created by the management. It has actually come to the finding of this tribunal, my lord, wherein it may be seen that the management workman has said that he has not seen the records. He does not have any personal knowledge with respect to working of 240 days. My lord, on the contrary, for 8 workmen were examined, and they have in absolute coherence has said that they have worked and with the respective dates of their appointment. Also, they have pointed the appointing authorities. Specific names have been taken of the branch managers and whatever appointing authorities have. They interviewed them and they have appointed them. But apart from that, they have produced the discharge vouchers, the letter, the authorities that were given to them because they were doing the messengerial work. They were given the authorities so as to service of some letter, service of some material so as to be submitted to some other branch. They have produced all those there. It categorically shows that the workmen were working in the absolute in the employer-employee relationship with the bank and for more than 240 days. It has been the categorical finding of the tribunal at least. And the whole thrust of the argument of the management is that there was a contractor through which they have all the 13 workmen have been employed. But if my lord will see page number 36 of the award, the finding of the tribunal with respect to the agreement or contractor that the management was asking about is that it would be proper to mention here that the management of State Bank of India has stated that Satyendra Singh of Messrs. Santosh Electricals was given a contract for electrical maintenance and he had never worked as an employee of the bank. Further, the management has also stated that the maintenance of security of cycles shed of bank staff was given on contract and no employee had been appointed by the bank for that purpose. At this stage, this is the finding, my lord. At this stage, it is important to mention here that Exhibit M1 series are documents relating to grant of contract to Jogeshwar Prasad for watching off and guarding all vehicle of the cycle stand near bank. But it has nowhere been mentioned that Vinay Kumar Sinha, Ajay Prasad Srivastav were engaged by the contractor for that purpose. Not further, the exhibit M2 series shows that the contract was given to Santosh Electrical for maintenance of the contract of electrical fitting in the premises of the State Bank of India. But it has nowhere been mentioned that Satyendra Singh was given the said contract for maintaining electrical fitting in the bank premises. That is the categorical finding of the tribunal, my lord. The case of the management has not been proved that there was a contract, or moreover the workmen were employed through the contractor. That is why this finding is there, that the employees were working for more than 240 days. My only limited prayer is for enhancement of the claim.
All right. May you have to say anything for that?
Yes, my lord. It's only limited submission that whatever prayer for enhancement that has been made showing the period of service, etc., we have disputed. We have said there is no finding of the learned tribunal saying that you have worked from this date to this date.
Don't repeat what you have already.
Yes, my lord, sir, that is what we have denied it. We have
say anything in rejoinder what he was to.
No, my lord. What I'm simply saying is that we are sticking to the points that we have raised. An alternative argument is that if your lordship finds that we amount because it is highly excessive.
All right.
That's all.
Order.
Obliged.
Item 56, Mr. Amitabh Bhatt.
No one appears.
Your Lordship,
No one appears for the petitioner. This writ petition is pending since 2013. Where the petitioner is for challenging the letter dated 3/7/2013 by which the candidature of the petitioner for LPG distributorship was rejected on the ground that he did not possess the minimum liquid fund of rupees 10 lakhs. And the certificate from his parents was not filed. What is the present position?
Your Lordship, my instructions are that in March of 2016, the LPG distributorship was already commissioned in somebody else's name.
It is stated that the LPG distributorship has already been commissioned in 2000?
In March of 2016 itself.
2016. By effects of time, the petition has become unstructured.
Obliged.
Dismissed accordingly.
Item 57, Mr. Aksheshwar Kumar.
No one appears. Petitioner challenges the notice under section 13(4) of the Surface Act 2002. The writ petition is pending since 2013. The remedy available to the petitioner was to approach the DRT in terms of the judgment passed by the Supreme Court in State Bank of Travancore versus so-and-so. Present status is not known in absence of the counsel for the petitioner. The petitioner does not seem to be further interested. The petition is dismissed.
Item 59, Mr. Raghunathan.
58.
Withdraw.
Who is appearing in this case for respondent? UPCL. The petitioner by way, no one appears for the petitioner by way of this petition pays for quashing of advertisement dated 28 June 2013. The writ petition has not been pressed to service for almost 10 years now. The advertisement issued in 2013 would have already attained. What is the position of this advertisement?
Lordship, till date, Lordship, it has not been allotted to anybody. I just inquired from the authority.
The advertisement was issued on 28 June 2013. However, the council for the respondent states that till date, no action has been taken on the said advertisement. After a lapse of 10 years, this court deems it appropriate to direct the respondents to issue a fresh advertisement and will not act on the old advertisement.
Well, if so advised, madam.
No,
because
you just now gave us this. This is your instruction.
Instruction is that it has not been
Petition stands disposed of accordingly.
That is there, my lord. But Lordship, if my lord will direct for if it is not feasible now, after 10 years, if that site is
fresh
not
advertisement, if they so choose.
Much okay, much okay.
Item 61, Mr. Prakash Chandra.
Yes, my lord. I have approached before my lord for setting aside of the order dated 17th day of June 2022, my lord.
7th June or 17th June?
7th day of June 2022, my lord, whereby the allotment has been cancelled, and further the
allotment of what?
Allotment of land, my lord, wherein plot number 11 having an area of 8,000 square feet situated at industrial area Haji.
Why was it cancelled?
My lord, the cancelled the region which was assigned for the cancellation because there was no industrial activities was going on. That's why.
Filed an appeal against that order?
Yes, my lord, I filed an appeal. And
you mentioned in your appeal that the industrial activity is going on?
Even, my lord, from the impugned order, it also cleared, my lord. It is Annexure 7, my lord, page number 22, my lord. क्षेत्रीय प्रभारी औद्योगिक क्षेत्र हाजीपुर के प्रतिवेदन के अनुसार आवंटित स्थल पर 4 दीवारी एवं कारखाना भवन निर्मित है। कुछ पुरानी मशीनें जीर्ण एवं शीर्ण अवस्था में पड़ी हुई है। परिसर में का उपयोग गार्ड के द्वारा परिवार सहित आवासीय घरेलू के रूप में कर रहे हैं। My lord, this is the region assigned. My lord, what happened in this case, my lord? Land was allotted for the set of the industry of the drinking water and soda water, my lord. And the said unit was going in loss, my lord. That's why the petitioner filed an application for the change of the product and change of the name, my lord. The same has not been entirely considered and the allotment has been cancelled, my lord. If, my lord, some time may be granted, my lord, I am ready for the production, my lord.
Even of the change product, new product.
Yes, my lord. Yes, my lord.
You don't want to go for that same old business.
Because, my lord, in that locality, there are a lot.
So that may not be viable.
Yes, my lord.
What do you say? What is your reply?
My lord, I have received instructions. My lord, in this case, allotment to third party has been made. However, possession has not been given.
My lord.
Huh? My lord, this plot of land has already been allotted to a third party.
My lord, possession has not been given yet, my
lord.
How
can that be allotted when they have not taken possession?
My lord, I may file a counter affidavit in this case after within this week itself, my lord.
You show that you have allotted to someone, or are you saying it on your own?
My lord, I have received instruction orally, my lord. I will file
from
it
whom?
From the concerned authority, my lord. From the
What
respondents.
is the name of that?
My lord, Biada, my lord. Biada, Bihar Industrial.
What is the name of the person to whom it has been allotted? And how? Have you issued a notice? Public notice?
Yes, my lord.
Or is it on your own?
No, my lord. It was after issuance of a public notice and consideration by the project PCC cum land allotment committee. Thereafter, the allotment was made.
Also for the respondents, shall file their. You have filed a supplementary affidavit. किसने file किया आपने?
Because, my lord, this fact has not been intimated, my lord. The land in question has been allotted to some other person, my lord. Even, my lord, kindly see the last order, my lord.
Nee, but where have you said the? You were asked to file, but there is a status quo order. How could you not?
Yes, my lord, it was allotted earlier, earlier to that status quo order. It was prior to that, prior.
Also for the respondent state that
Biada, I am for the state.
Biada has allotted the plot prior to the passing of the status quo order dated 30th January 23. Also for the petitioner submits that the possession is still with the petitioner. Counter affidavit has not been filed in spite of the specific directions issued by the division bench on 30th January 23. In the interest of justice, last opportunity is given to the respondents to file their counter affidavit within 3 weeks. In the meanwhile, status quo as on date shall be maintained. Status quo as directed on 30th January 23 shall continue to operate. This case after 3 weeks straight to go.
Item 62, Mr. Prakash Chauhan.
What's your case?
Yeah, my lord, in fact, I have 6-2. My lord, in this case, we have purchased the land from third party and Biada has given me permission. For that, we have paid the fees what Biada was asking for. But by mistake, 12 lakhs rupees extra has been paid to the Biada. And Biada is not ready to lease me for 90 years, which is the normal decorum for the Biada to lease the land. They are only leasing me for the rest of for 32 years. They have the third party has enjoyed it, and rest of the period they are leasing it for me. But I say I'm a new leasee, I should be given 90 years. This is all what my case is, my lord. When new lease has been given to me, counter has to be filed, my lord. I say
counter be filed after 4 weeks.
My lord. Obliged.
Okay. Item 63, Mr. Vikas Kumar.
My lord, impugned order in annexure page 20, my lord, by which the industrial plot allotted to petitioner has been cancelled by the Biada, my lord. My lord, the land was allotted to the petitioner, my lord. My lord, I was doing the industrial activity, my lord. I am still ready to do the industrial activity, my lord. Even in the division bench, my lord, I have annexed the order. In view of the order passed by division bench, I have given undertaking in this writ application, para 23, my lord. Para 23 of the writ application, my lord, that I am ready to do the industrial activity, my lord. Very categorically, I have stated, my lord. Page 15, my lord, 23 starts from there, my lord.
Your lordship, third party right has already been created and possession has already been given.
My lord, he has not furnished anything to me. My lord, they are just, when I filed the writ application, every tantrum started thereafter, my lord. I have filed an IA here, how the other officials were behaving with me. They are beating me. He is an old person, my lord, and forcibly trying to grab the land. To whom they have allotted, how they have allotted, even till date, I have not been informed, my lord.
You are having possession?
Yes, my lord. On the part, a portion of the land, he is saying.
The respondent shall file their reply. In the meanwhile, status quo shall be maintained.
Obliged, my lord.
Your lordship, my submission that you already been allotted a
possession. No, you file your reply.
Item 62, Mr. Ashok Kumar.
This application is against
against the order by which my application to transfer the industrial plot is in the name of my father be given in me has been rejected, Your Lordship. And subsequently, the industrial plot has been cancelled.
There is an alternative remedy of appeal which has not been assailed, Milos, and this writ application has been directly filed.
Lordship, there is no provision of appeal against the refusal of.
It is cancellation. It is against cancellation. Challenging the cancellation order, they have come before this honourable court.
You cancelled it on what basis?
Now, Milos, what had happened that even prior to 2021, when his father died, the unit was not into production. Thereafter, he filed an application for being impleaded in place of his father without the no objection of the other heirs. That was the reason that his application for being impleaded in place of his father was not allowed. Because if there are other
notice,
sorry, it was replied. He filed an application. His application was replied for furnishing. I'll file, Milos.
I have applied all the documents, Your Lordship, even with the affidavit of the court, Your Lordship.
I'll file the reply, Milos. My instruction is this that it was not.
Meanwhile, the plot shall not be allotted to any third party.
Obliged.
If the reply be filed within 4 weeks, in the meanwhile, the plot concerned shall not be allotted to any third party.
Obliged.
Against this application, against the cancellation, Your Lordship, against the cancellation of the plot and the subsequent order passed by the appellate court, Your Lordship. It was an auction purchase plot in which, from by the Annexure 1, it was auction purchase from the Bihar State Financial Corporation. Subsequently, at Annexure 2, the Lordship will find there is no due certificate from the Bihar Industry, BIADA, as well as the Finance Corporation, Lordship. Next, Lordship, it is the.
What is the ground on which they have cancelled it?
There is no industrial activity, Your Lordship. In fact, after purchase, the name was not changed in my name, Your Lordship. Industry was earlier standing in the name of someone else.
And in the auction condition, it is there that you will start the industrial activity?
Lordship.
It was not changed in your name?
No, despite giving application twice.
He purchased from the BSFC, Your Lordship, not from the BIADA, because this property has already been mortgaged before the Bihar State Financial Corporation. So and he purchased from the Bihar State Financial Corporation.
So did you, then your conditions would not apply on him?
Your Lordship, industrial activity he has to start, Your Lordship. So, Your Lordship, well region order passed, Your Lordship, kindly see page 36.
Was it put in his name? He says it was never put in his name.
Your Lordship, kindly see his document has not been produced. Your Lordship, kindly see page 36. I passed the region order.
Have you filed your reply?
In appeal, Your Lordship, region order has been passed. Page
File
30.
your reply. Reply be filed. In the meanwhile, the plot shall not be allotted to any third party.
Lordship.
Item 66. Mr. Kamla Khan.
Because, sir, most arbitrarily, my lord, the land allotted to me has been cancelled, Your Lordship. And before cancelling the lease agreement, Your Lordship, what they have done is that they have allotted the land to some private respondent of 4 my lord. Then I had moved before this honourable.
Are you in possession?
No, my lords. I have been dispossessed.
You have been dispossessed?
My lords. In my place, somebody else has been inducted, my lords.
Have you pleaded it as a party?
I have been pleaded, my lords.
Issue notice.
Respondent of 4.
Who appears for BIADA? Who is the standing counsel for BIADA? You appear? Counsel to provide a copy of the writ petition to the standing counsel for BIADA?
Yes.
Who will also take instructions, file reply. Respondent number 4. We issued notices by ordinary as well as registered post. Returnable 5 weeks.
Obliged. Some date may be fixed, Your Lordship. Otherwise, we'll not.
5 weeks.
5 weeks. Obliged.
Item 67. Mr. Neil.
Yeah, Lordship. In this case, my lord, Annexure 4, kindly Lordship, look, my lord, in this case, the National Commission of the RTI, my lord, direct to the State Bank to supply a copy of the same. In this case, my the land, ancestral land has been auctioned to mortgage by the ancestral of the
petitions, my lord. And thereafter, my lord, one of the uncle, my lord, of the petitioner has been sold out the said land, although it has been mortgaged before the bank without deposit the entire amount, my lord. Thereafter, the notice has been issued to the father of the petitioner under Special Act, my lord. Thereafter, petitioner has been informed to the bank that the said mortgage land has been sold by one Chandramati Tiwari to Hiralal Shah, my lord. Thereafter, the bank has not been taken any action, my lord. And thereafter, again, my lord, the Chandramati Tiwari, the uncle of the petitioner, has been sold the same land and purchased the tractors, my lord. And now the surfacing notice is going to be issued against the father of the petitioner. Father was died, my lord. So petitioner learned about only that under the RTI that how he can grant a loan in the name of my father and uncle and the entire family member, and how can the land is sold. And actual 4 kindly lordship look, my lord, under the RTI petition we filed before theirs, my lord. They have refused, my third party is not allowed to take any information. Thereafter, the Central Information Commission, my lord, Delhi, my lord, has been directed by the NHS board, my lord, that it should be issued, supply the said document. But they have not supplied, my lord. I was filed a petition before the Central Information Center, my lord, Delhi, that to comply with their own orders. And I have filed a petition before the chairman of the bank, 6 and 7, my lord, the branch manager. My lord is matter.
So what are you here for?
I'm here for, my lord, that the direction and Central NHS 4 may be compliant, my lord.
But for that you have already gone there?
Yes, it has been pending, my lord, since 2013.
So you can't be asking here as well as there.
My lord, actually, my lord, the matter is, I have filed a petition before them and the branch manager, chairman and the Central Commission also, Lecture 5, 6, 7.
Minister has already approached the Central Information Commission for non-compliance of its order dated 11/6/2012 relating to non-supply of information. Since the same is pending before the concerned, the presented petition will not be maintainable.
So you will also make direct to the Central Commission to report my petition within a stipulated period.
Item 68. Mr. Shakti Suman Kumar.
I kindly permit to withdraw this application.
Council please to withdraw the petition. Dismissed as withdrawn.
Item 69. Mr. Nandkishore Prasad Singh.
Lord, I may be permitted to withdraw this application. So it will become infructuous. हो गया.
As the writ petition has been rendered infructuous, dismissed as withdrawn.
Item 17. Mr. Dhananjay Nath Tiwari.
Pass over for today.
अब कब पास ओवर करेंगे?
For today only. For personal difficulty. For today.
What is the difficulty? You are Dhananjay Tiwari? No. Adjourned. 4 weeks.
Item 71. Mr. Donacharya.
Permitted to withdraw.
Council please to withdraw the petition. Dismissed.
Item 72. Mr. Vijay Anand.
In this case also he has to argue. Dhananjay Nath Tiwari has to argue this case. May come tomorrow.
Adjourned. Council not available. Adjourned. 4 weeks.
Item 73. Mr. Indu Bhushan.
Who appears for SBI? You appear? You are in this 73 number item?
74.
Is it 74 or Lal Bahadur Roy?
In the next case.
But you are for
SBI.
SBI. So take notice, file your reply. Also, to take notice, file reply. Name is you appear for whom? What's your name?
Manu Tripurari.
Oh.
State Bank of it.
Counsel who appears, Manu Tripurari, who appears for SBI, is directed to accept notice and take extension file reply.
Item 74, Mr. Satish Kumar Soni.
In this case, my lord, pleading has been completed, my lord.
So we have filed the counter affidavit.
I have also filed the rejoinder of the counter. Petitioner is a retired teacher, my lord. 2,36,950 rupees debited from the pension account of the petitioner on my lord on 5th February 2020 from the saving account of the petitioner, my lord, by the respondent bank. Regarding illegal debit, the petitioner complained the matter to the regional manager, my lord, SBI Motihari by registered post on 13/10/2021, that is Annexure 1 address 14, my lord. Again, he given Wakaltan notice, my lord, that is Annexure.
How can you come here for this relief? This is going to be looked into by this court in red jurisdiction.
My lord.
Who is going to prove all these documents? Go to civil court. Where is the occasion of writ petition to be with regard to your issue, personal account problem? Some amount has been credited wrongly or debited wrongly.
One thing, my lord, I would like to submit, my lord.
Are these kind of writ petitions are being entertained in this High Court? ये सिविल कोर्ट का है, प्रूव करना पड़ेगा आपको कि कितना पैसा आपके बैंक से निकला, किस दिन निकला।
फिर एक चीज कह देना चाह रहे हैं,
इसके लिए आप हाई कोर्ट आएंगे।
कंज्यूमर प्रोटेक्शन एक्ट में हम गए हुए थे, लेकिन वहाँ रिलीफ हमको मिला नहीं। उसके बाद फिर ये लोग सर्टिफिकेट केस में चले।
तो कंज्यूमर प्रोटेक्शन में नहीं मिला तो अपीलेट फोरम में जाते।
अपीलेट फॉर्म में नहीं गए,
बस हाई कोर्ट में आ गए। एवरीथिंग का, सब चीजों का एक ही इलाज है, अमृतांजन।
लिबर्टी फिर दे दिया जाए।
My lord, sir, by way of this petition, praise and under. The dispute is purely a civil matter. Writ petition would not lie, dismissed.
Item 75, Mr. Rajkumar Mishra, in person.
And it's legal, Your Lordship. And petitioner's son.
You are in person?
Yes, Your Lord.
Final arguments के लिए?
Yes.
What are you praying for?
Your Lordship, petitioner son taking loan, educational loan under a spent credit card, Your Lordship. May I kindly see Annexure 3, the circular by letter 27/9/2016, Your Lordship, page number 14 and 15, Your Lordship. In para 13, Your Lordship, it has been stated that no interest will be charged for that kinds of loan, but respondent banks has charged 10% compound interest, Your Lordship. May I kindly see
interest, go there.
I have filed representation before all respondents, Your Lordship, but no action has been taken.
File a civil suit. Wrong interest अगर ले लिया charge कर।
I am spent that circular passed by the state government, Your Lordship. There is agreement between the banks and respondent, Your Lordship. They should obey the circular, Your Lordship. There are agreement between them.
Who advised you to file a writ petition?
Yes, Your Lordship.
किसने आपको रिट पिटीशन के लिए राय दी? पहले तो हम उसको पकड़े, जिसने आपको राय दी है कि हाई कोर्ट में रिट लगाओ।
Already.
आप वकील हैं? तो आपने सोचा हाई कोर्ट में लगेगी सब चीजों का? दावा करिए भाई, दावा करिए, पैसा लीजिए वापस। इन्होंने अगर आपसे 10% ब्याज ज्यादा ले लिया तो
I have filed representation before
अरे
all
भैया आपसे
respondent,
बात ही नहीं
May
समझ।
kindly see an actual page, may kindly see
The petitioner said and under the dispute is purely civil nature, for which evidence is required to be produced and contested. Dismissed. It's liberty to file a civil suit.
Your Lordship, I am a student. I am a student. I am a student, Your Lordship. A student. This loan has been sanctioned. Student credit card, Your Lordship.
So, what can we do? There has to be a correct forum. I am not sitting here in a civil court. Go in civil court.
There is agreement between the mechanic.
All right. So if there is an agreement between you and him, na?
No.
Or between him and some
bank
and the department.
Yes, Your Lord.
And you are a consumer for the bank.
Yes, Your Lord.
So there is an agreement between you both, a contractual agreement that they will only take this much interest.
Yes, Your Lordship. May kindly say counter affidavit
And
filed by the.
And if they have taken wrongfully.
May kindly say counter affidavit
Mr.
filed.
Counsel or Mr. Rajkumar ji, though you are a vakil, interest, agar in any manner if it is taken more than what was required to be taken, you will have to go there, not in writ. Claim it along with all kinds of interest.
May kindly pass over for today, Your Lordship. I will go tomorrow, Your Lordship.
Kya?
May kindly pass.
For what?
In this case, senior counsel has been engaged. Today he start for personal work. May kindly pass. May kindly pass over. Only pass.
Pass? Tomorrow?
Yes.
Saturday? Tomorrow. That's great.
Item 76.
My Lord, I pray for 1 week time with consent, my Lord, for filing supplementary affidavit to bring some necessary facts on record, my Lord.
What is your case?
My Lord, it's a case into the auction and giving a position of a company, my Lord, dairy factory, my Lord. I have taken consent from the opposite party, my Lord.
Filing of a supplementary affidavit can only be as per the directions of the court.
Well,
you can't be filing whatever is happening day to day. Tomorrow you will say that this thing happened during this period, so I would like to file it.
Facts has come, my Lord. So we want to bring on record, my Lord, for the adjudication, my Lord. This 1 week time, my Lord.
Tell us. If we will allow, we will allow. If we do not allow, what are those facts which will go to the roots of the case and required to be looked into?
Single bidder has been awarded as against the rule of the.
It has already been awarded the contract.
My Lord, the auction, my Lord, the auction of the dairy company has been dairy factory, my Lord, has been given. Tender was notified, my Lord, and notice. The single bidder appeared, my Lord, and he has been awarded.
So you did not appear?
My Lord.
The auction you did not participate?
My Lord, I have not given even notice, my Lord. I was the owner of the factory, my Lord. And I was not noticed, my lord.
What is your original case? You tell us this.
My lord. The quashing setting aside the order dated 10/11/2022 contained in memo number so and so, my lord, under the signature of the respondent number 2 under the auction sale of the mortgaged hypothecated assets of the industrial unit of the petitioner, my lord. So the auction sold to the private respondent, which is arbitrary, malified, malicious, illegal, my lord. That was my original prayer, my lord. But after that, auction has been taken place. Position was given.
Auction has already taken place.
My lord. Position has been given, my lord.
That's what, that is a consequential effect.
My lord, only 1 week time, my lord. Some necessary facts I have to bring on record, my lord. And I have taken consent for the from the advocate of the respondent, my lord.
You are challenging the auction itself.
My lord.
On what ground?
My lord, it is against the notification rule of the BSFC, ma. Even the single bidder, one advertisement, my lord, it is the, I have filed an IA also, my lord.
What you have,
in this, my lord.
Finance rules are section 29, what is it?
Section 29.
Same section 29?
Yes. Exception.
Just 1 week time, my lord, to bring
For
some.
For what? There is nothing. Tell us what is there in your case.
Well,
you have not been able to satisfy their auction. What is error in that auction?
My lord, there is a 2-tier notification, my lord. I have filed an IA, my lord.
Are you saying that you will be able to repay the loan?
My lord, no. BSFC follows 2-tier process of advertisement before finalizing.
How are you concerned once they have already taken over possession under SFC section 29? The next, so far as auction is concerned, you are nobody. Once the land once the property has already been taken over.
My lord, but
what is your locus of challenging the auction?
I was the owner of the industry.
You were.
And without any notice to me, my lord.
So far as section 29 is concerned, proceedings have been already taken against you. You did not challenge them.
My lord, I was not even informed. I have no knowledge of that, my lord. That's why, my lord, I pray only for 1 week time, my lord. Only 1 week time I pray, my lord.
How is 1 week?
In this case, my lord, senior is also engaged, my lord. And to bring on record, my lord, some facts, my lord, I need 1 week time, my lord. Just one prayer, my lord. I have intimated my learned friend also, my lord. And he has given consent, my lord.
We would like to know from you. Either you say that I am not prepared.
My lord, in this case.
Or you tell us what is this after section 29 action taken against you.
Then, my lord, kindly pass over for 2 cases. I will call senior, my lord. He is ready in this case, my lord.
Council wants time. Start with 3 weeks. बताइए आपका क्या लोकस है, पता करके बताइए।
Item 77, Mr. Sasi Bhushan Kumar.
Also, in view of Lordship order against supplementary affidavit filed, Lord, by undertaking given by the Honorable pursuant to the order undertaking given by Honorable Court on 25/1/2023, Lordship. Last week, order number 2, Lordship.
Have you filed the undertaking?
फाइल कर दिया, अंडरटेकिंग फाइल कर लास्ट में फाइल कर वर्ड में था, मीनिंग वही था कि हमने विड्रॉ किया लॉर्डशिप के परमिशन से और फ्रेश फाइल कर दिया, लास्ट पे जब ब्रीफ में होगा
कर दिया?
हाँ, मुझे कर दिया।
Have you given you a copy of that undertaking?
I have got the copy of one copy of.
What to what court order वही।
कब किया?
ये हम 14 मार्च को।
Council states that a fresh undertaking has been filed on 14th March. Registry to place the same on record.
Third party right taken. हमको ये डर लग रहा है।
My lord, may I pray one thing, my lord? Appellate order is under challenge, my lord. Ground is, my lord, that the petitioner have not given notice. Petitioner himself filed, my lord, appeal before the appellate authority, my lord. Twice, my lord, opportunity was given to him, my lord.
Say your breath.
My lord.
The counsel for the
I put the state, my lord.
Counsel for the petitioner submits that the undertaking having been filed in terms of the order passed by this court, till further orders are passed, status quo will be maintained. Counsel for the Viada
I have no objection.
has no objection. In view thereof, the status quo shall be maintained. No third party right shall be created. Status quo मत काट नहीं तो आप काम ही नहीं करेंगे.
Monday,
Next week.
Reply not filed. Item 78, Mr. Mahant Kumar Sharma. Mr. Mahant Kumar Sharma.
No one appears for the petitioner. The petitioner has prayed as under. Essentially, the petitioner seeks compensation for which the remedy lies filing of a civil suit. Dismissed as not maintainable.
Item 79, Mr. Rajiv Ranjan Singh.
What is this supply they are asking? He is asking for.
Lord, sorry, my lord, I don't have the file right now, but then it appears that it is
The petitioner by way of this writ petition prays as under the contents of the writ petition do not reflect as to what the petitioner seeks to supply to the Bank of India.
It is termination of this supplier.
A supplier to a bank is essentially a contractor, and the terms of contract govern such relations. The writ petition would not lie for such purposes, only frivolous, dismissed.
Item 80, Mr. Anuruddh Kumar.
My lord, 2 weeks time we will grant it. उनके चाचा का भूज हम चाचा डेथ कर गए हैं पेटिशनर के वो करके 2 सप्ताह के बाद रहते हैं.
ये तो ऑक्शन हो गया 2011 में मकान, अब तो वो और आगे कहीं कहीं गया होगा.
कुछ जानकारी नहीं है मेरे को।
By a flux of time बेकार हो गया आपका केस।
उनके प्रेजेंस में जो भी ऑर्डर।
इनकी प्रेजेंस में
अनंत कुमार भाई
आगे कर दो। Date not available. List after
2 weeks.
2 weeks.
Item 81 is Priya Gupta.
I would like to withdraw your lordship as the matter stands in front of us. Withdraw.
Council prays to withdraw the petition.
Item 82, Mr. Arvind Kumar.
Lord, I need further 4 weeks time to file counter affidavit.
Oh, 10 years is not enough.
Lord, the brief was served after the last date. Copy was never served me for 7 years.
For 7 years?
Yes, filed in 2000.
But what is your case? In 2013, what was your case?
Of the last date,
Last date.
अरे भाई ये तो डीआरटी का ऑर्डर है।
Lord, DRAT.
Challenging the order of the DRAT.
Yes, my lord, that is
Appellate tribunal's order.
My lord.
In this case, no, Mr. Arvind Kumar Jha arguing the case, my lord. उनके फादर का जो हॉस्पिटलाइज हैं, तो 2 वीक के बाद इसको कीजिए। लास्ट ऑर्डर में हुआ था काउंटर देने के लिए।
File your reply.
4 weeks.
8 weeks. 8 weeks further time granted to file reply.
Item 83, Mr. Satya Prakash.
What are your instructions?
LOI has already been given in the month of May 2013 to the
2013
to the private student.
Stated that the HPCL dealership has already been commissioned by issuing of LOI in May 2013.
To the private student number 5.
The writ petition challenges the merit panel prepared on 5/7/2012. After 2013, the writ petition has not been pursued. Almost 10 years have passed by. The court does not find any case for interference at this late stage. Dismissed. Yes.
Item 84, Mr. Direshwar Mishra.
On last occasion also, Milord Mohan had appeared on behalf of the petitioner, Milord. The writ petition is not maintainable itself, Milord, because the petitioner has prayed for staying the proceeding initiated under the SURFACE Act, Milord.
What happened in the district forum?
Milord, it has been mentioned that they have moved before the state forum, Milord. In this case, so far the matter of SURFACE Act is concerned, Milord, the state forum has no jurisdiction, Milord.
They went to the state forum for some other purpose.
District forum. They have mentioned that district forum में हुजूर ये गए हुए हैं।
The petitioner says the notice issued under 13(4) of the Surface Act against the said notice appeal proceedings under 17.
Under 17 of the Surface Act.
Filed before the DRT.
Ji.
Granting liberty. The writ petition is dismissed on the ground of efficacious alternate.
Obliged.
This may declare no one appears in the case.
Item 85, Mr. Ashok Kumar Jha.
Your Lordship, we seek 2 weeks time, Your Lordship, to file supplementary.
For what do you want supplementary affidavit?
Your Lordship, we need to bring some.
What you could not satisfy in the main petition, how can you do it in supplementary?
Your Lordship,
unless we ask you something more.
Your Lordship.
Law pleadings does not allow supplementary affidavits like this.
Sorry, Your Lordship. Your Lordship, I have been instructed by my senior, since he is seriously ill, so he asked me to take 2 weeks time. There is to be a supplementary is to be. Since arguing counsel is seriously ill, he asked me over phone to take 2 weeks time. As a supplementary would also be required in this case.
Okay. Counsel for the petitioner is unwell.
Unwell, Your Lordship.
Put up after 4 weeks.
Item 86, Mr. Rajiv Ranjan Kumar Pandey.
My Lord, I pray for pass over for the day. Pass over for the day. Petitioner counsel is not well today.
Petitioner counsel is not well.
Well.
इसमें हुजूर अपील में गए हुए मेरा इंस्ट्रक्शन आया है जिसमें कि बियाडा के कैंसिलेशन के अगेंस्ट ही अपील फाइल किए हुए
पेंडिंग है
अब वो पेंडिंग है ये बताएंगे
तो
ताकि
मेरे पास फाइल नहीं है वो बोले
हम ये बता रहे हैं हम उनकी बात मान लेते हैं
तो कल सुन लिया जाए हुजूर
उसमें क्या सुनना
28/7/22 को पिटिशनर एक चिट्ठी दिए हैं जिसमें वो इंटीमेट किए हैं बियाडा को कि हम अपील फाइल किए हैं और 28/7 के बाद यहाँ हाईकोर्ट में एडिट फाइल कर दिए 13/1/23 को 4 महीना बाद उस बीच वहाँ अपील इनका पेंडिंग रहा होगा या अपील ऑर्डर अगर फाइनल हुआ तो उसको चैलेंज करेंगे
इन्होंने तो अंडरटेकिंग दे दी है ना आप यहाँ पे
अंडरटेकिंग कहाँ
यहाँ कोर्ट का आदेश था इनको अंडरटेकिंग देने को इन्होंने अंडरटेकिंग दे दी An undertaking has already been given by the petitioner. As further respondent may file its reply. Meanwhile, status quo. Meanwhile, the land shall not be allotted to any third party. अपनी अटेंडेंस मार्क करा लो आधी फीस ले लेना उनसे
Item 87, Mr. Pramod Kumar.
May I please, Your Lordship. Annexure 7 is under challenge, Lords, on page 39, whereby the e-auction in favor, e-auction sale, Lords, in favor of the petitioner has been cancelled. The entire deposited sale value has been forfeited. Lords,
what is the right of an auction purchaser? Except to take back his compensation amount.
Lords, he was not allowed to uplift the scrap. That is the Lords. He was not allowed to uplift the scrap. As per when the order, delivery order was issued.
Cancelled the auction, no?
Lords, first the delivery order was issued. The petitioner representative went to uplift the scrap. He was not allowed.
But you are an auction purchaser.
Lords.
And if they have decided not to cancel that auction, where is your right?
Right is not there, Lords, but it has been cancelled, Lords, on the ground that I have not uplifted, but I was not allowed to uplift. That is the Lords.
That's another thing, but stands cancelled, na?
Order was passed, Lords, in violation of principle of
I think
mutual
the
justice.
judgment is just recent one. Supreme Court has just given.
But it's
Right of auction purchaser.
Lords, that is. It was, but Lords, it was passed in violation of principle of natural justice. I have next another order, Lords, passed by
But
this on
there is no right. So if there is no right, there is no consequent principle of natural justice. It is only where there is a right vested in a person. The same cannot be taken away without following principles of natural justice. That is the principle. So if there is no right, then there is nothing.
But any action which has an adverse consequences upon the petitioner, my lords. So, lords, that is there. If there is a right, then, my lords.
If a right, if a right has been vested.
My lords, but my lords, in similar circumstances, the same petitioner, my lords, an extra 10. In that case also, my lords, they have passed the order without complying the provisions of natural justice, and that was allowed by the Supreme Court itself, my lords, on 11/8/2022, my lords. Kindly see the next 10, my lords. On page 47 it starts. The same petitioner, my lords, and the same railway, lords, there also was the petitioner was the Honorable Court has held that since it was passed without following the, without giving the opportunity. Relevant is
the amount of security has been forfeited.
My lords. Entire, I have deposited the entire sale value. Thereafter, the delivery order was issued, and that has been forfeited.
But the auction was cancelled, and your security amount has been forfeited.
Forfeited, my lords.
You said that everything has been returned back to you.
No, lords. Can we see the SS 7, page 39, which is under challenge? It has been duly forfeited.
Issue notice. Who appears?
Lords, last time somebody has appeared, lords.
Council may supply a copy to the standing council appearing for the railways. After 2 weeks, 3 weeks.
Item 88, Mr. Amrendra.
Issue notice.
My lord, I am appearing on behalf of the bank. My lord.
Why have you not returned back the amount?
Lord, as per the provision of
If
surface
the
yard.
e-auction has been cancelled.
No, it has not been cancelled, my lord.
What is
my lord,
this?
I have not.
In front of auction amount, who is the highest?
My lord, it was not cancelled. Petitioner failed to deposit, my lord, within the stipulated time. And as per the rules of the surface rules, my lord, that amount is required to be forfeited. My lord, just now I am not with file, my lord. It may kindly pass over for the day, my lord. Tomorrow I will assist the court, my lord.
Council wants time to file reply. Council for the bank wants time to file reply. Let's after 4 weeks.
Obliged.
Item 90.
89.
Mr. Arthur Chaudhary.
89.
88.
On behalf of the state, my lord, in this case, my lord. As per Surface Act, my lord, only simply notice was issued for vacate the mortgage property, my lord. Simply notice was issued, my lord.
Notice under 13(2).
Yes, my lord. Handing over the property to the bank, my lord.
But how could you issue this
Notice, my lord.
notice?
In the next year, my lord. Page 14, my lord. Page 14, my lord. Petitioner has failed to pay the loan amount, my lord.
He is ready to pay.
Ready to pay to my lord, my lord. I have no any objection, my lord. Yes, my lord.
फिर revise the installment.
Yes.
It is his personal home loan. कोविड के टाइम में आपने ऐसे लेफ्ट राइट खूब मजे लिए सारे मैनेजर्स ने.
फिर इसको टाइम दे दिया जाए.
In some fit case, we are going to get an inquiry done with regard to all your managers, how they have done these auctions during just after the COVID period. Small loans for houses, purpose, flats. You've not taken the loan back from big shots, but these people are being harassed by you. You file your reply.
All right.
Counsel for the Spotted Bank shall file its reply just after 4 weeks.
Item 90, Mr. Amren Kumar.
My lord, in the light of the order passed on 31st, I have filed my undertaking, my lord. This is the Ada matter. I have filed undertaking on 4/2/2020.
Undertaking has been filed in terms of the order passed by the court dated 31st January 23. Counsel for Ada may file his reply. List after 5 weeks. In the meanwhile, no third party right shall be created.
Item 91, Mr. Rakesh Vachai.
This case, my lord, as per order dated 31/1/23, my lord, the petitioner already filed undertaking, my lord. And thereafter, on order number 3 dated 7/2/23, the Honorable Division Bench again directed the BIADA, a state council, to file counter, my lord. But till today,
Same order जो अभी किया है, file
offline.
Okay.
Item 92.
Your Lordship, pass over for the date because of personal difficulty.
This day is going to be over. Where are we going to pass over? Regularize the loan account. You can go to the DRT for the purpose. Petitioner has an efficacious, the petitioner prayed as under, has an efficacious alternate remedy to approach the DRT for the request as prayed for hearing above. Keeping in view the law as laid down in Bank of Travancore, so and so, writ petition is dismissed with aforesaid liberty.
Item 93.
Lordship. Lordship, allotment of land has been cancelled by BIADA. Lord, the land was allotted on 8/6/2020. On 9/11/2020. Lord, because of COVID, Lord, the petitioner was not able to start the production of dal. Lord, the allotment was for dal mill. Lord, I have stated, Lord, in paragraph 14 and 15 that because of COVID-19 and because of death of the petitioner's father, he was not able to start the production activity. Now, Lord, he is willing to start the production activity. And he is also willing to pay the amount, Lord, 3,38,480 as demanded by the respondent. Lord, should they inform under which head, Lord, they are demanding?
Which head is for them to adjust. You deposited because it is against, it is due against you.
And Lord, I'm also willing to start the unit, Lord. That is, Lord. Because Lord of COVID-19, Lord,
If he is ready to deposit, what is your problem with you? Let him give an undertaking also that he will do it in 6 months, the same condition. That will we dispose of the matter.
Lordships, after allotment, Lordships, when the inspection was done, Lordships, it was closed. But since my lord is
the counsel for the petitioner submits that the petitioner's father expired during COVID period and was unable to start production. The petitioner is ready to deposit the amount demanded by the BIADA, namely 3 lakh.
My lord, the amount is 3,38,480.
38,480. And he is in the process of starting production also. Learned counsel appearing for the BIADA wants time to take instructions?
Lord.
In the meanwhile, the petitioner may deposit the amount and also give an undertaking before this court expressing as to by what period he shall start the production in terms of the conditions of allotment. The undertaking may be given within period of
4 weeks.
4 weeks from today with advance copy to the counsel for the respondent. Para. In the meanwhile, no third party rights shall be created on the property. Question. Any other matter?
Item number 95, my lord, I have to seek permission to my lord, change the subject matter because it is not a trade and commerce matter, it is land related matter, my lord, group 22. Wrongly, I have mentioned, my lord, the trade and commerce, my lord, and office has also not pointed out the fact, my lord.
Make a correction.
Thereafter, my lord, roster will change, my lord. I will make correction in course of day if you lordship.
No, I will not allow you to even touch the court file. Not like this. File an affidavit along with correction.
My lord. So, my lord, 2 weeks time may be granted. I will, my lord, file a supplementary affidavit or IA.
Would amount to interpolation with the file, court file.
With permission of the court.
No, it's a court of record. We can't be allowing you to write by hand anything on this file.
So I will file IA, my lord, amending the subject matter, my lord, for which 2 weeks time may be granted, my lord. Item 95.
You'll write it, we'll get it listed after you move an application. Seek a permission, we will get it.
I will file IA for which 2 weeks time may be granted, my lord.
It is always there with you. You file it within 1 week and seek permission, we will get your case listed.
My lord, sorry. 95 serial, my lord.
हाँ तो हमने कॉल ही नहीं किया ना. Anything else? Any cases to be declared infectious?
My lord, serial number 97.
हो गया?
Of course, सरफेसी एक्शन, my lord, इसमें पिटिशनर जो है वो रिपे करना चाहते हैं लोन अमाउंट्स को. उसमें केवल हुजूर का एक डायरेक्शन हो जाएगा कि हाँ उसमें जो भी है उसमें इंटरेस्ट जो पेनल इंटरेस्ट है कोविड पीरियड में उनका अकाउंट किए हुए जो कि नहीं होना चाहिए था. तो उसमें जो भी लोन अमाउंट
दीजिए जो दूसरी साइड है आप उनको कॉपी दीजिए लगाइए.
दे दिए हैं.
ठीक है, देखें.